The government only affects code one final password in my favor. Review also discussed. They filed this report pending 2022. The matter relating to national increment. National increment. Those who have retired from 30th June 30th June, they will entitle for the one increment. Are you pending or give it? Next week.
This year, 19 to 2018, this matter is in list. Already 13 years of custody. That is another matter. This case was directed to publish document. LCA. That I have got that certificate.
What is the matter?
That is 2025.
Criminal appeal.
No, OGLS matter. OGLS.
Achha, give it.
Mention matter. Serial 520 by 18 Face matter. Face matter.
For what purpose you are filing?
Defective there, my lord. Thereafter, not listed, my lord. You will receive directly remove the defect, my lord. In the meantime, council check.
2018 criminal appeal.
My lord.
It has not been listed today, till today.
No, my lord.
It's a regular appeal or jail criminal appeal.
No, my lord. Regular appeal.
Pardon. Matter relating to appointment on the realization assistant petition challenging order of one single judge, where the honorable single judge rejected the claim of the citizen.
Land acquisition matter fresh admission.
Recruitment matters or appointment. Appointment matter. Recruitment has been successfully completed a written test for the drivers. The learned single judge are appreciated and a rate of appeal is on file.
Learned single judge has
Not consider the case of the petitioner.
okay against the single judge order. Give it.
Pardon to mention your, my lord, I am in DC, your lord.
In custody order from
I have to mention your lordship in
another criminal appeal.
WBC number.
1 minute, madam. 1 minute.
Appellant in custody for 18 years.
Give it. Yes, madam. Unmute yourself.
Yes.
Am I audible, your lordship?
Yes, yes.
I have to mention your lordship in WPC number 30018/23. That is Union of India versus Antaryami Behera. On the last occasion dated 22nd of October 2024, it was instructed to the respondents to file the rejoinder within 2 weeks, and it was listed to be instructed to be listed within 2 weeks. That is in the week commencing on
Union of India has challenged the order of the CAT or what? Union of India has challenged the order of the administrative tribunal.
Yes, your lordship.
You are the opposite party in that case.
Yes, your lordship.
You have
It
filed
was
your
instructed to be listed on the week commencing 11th November 2024, but unfortunately till that it was not listed yet.
okay, give the number. Yeah. All right.
That is WPC number 30018/2023.
All right.
There is
Yes.
a interim order also, interim
Yes,
stay also. May it be kindly listed shortly, fixing a
Already.
date, your lordship.
All the matters.
Supplemental list, item number 1.
The item number 1 matter. So for the contempt is concerned, that is in the
Contempt we are not.
So for the review by order dated 23/4/2025, lordship directed to file affidavit by the state to file with Tahsildar on fresh inquiry. The affidavit is ready, we allow 1 day to file. In course of the day, we will undertake to file. 23/4/2025.
What affidavit we directed to?
That is the fresh inquiry was conducted. There are some reports have come from inquiry that the how the land can be used for construction of road or not.
That I am.
Because previously it was directed in the PL to make construction.
That I am the petitioner in this case, my lord.
the in the writ petition, where the writ petition was allowed directing the municipal corporation to construct a road connecting to a tank that is called the Padma Pokhari, and it is coming within the municipal area. That this court directed after considering the counter submitted by the state.
That is
And
the.
municipal authority has also appealed. But after that, it was directed to construct the road in a particular time. But since they did not construct the road and did not implement the order, we filed the contempt. The municipal corporation filed a review petition. In the review petition, your lordship directed that since the earlier the report has been submitted and a fresh inquiry may be conducted, and let them conduct a fresh inquiry, submit a report about taking into consideration all the reports, whether the road is feasible there or not. Because they are alleging that there is a smashan, and that has been boundary has been constructed.
All right, the Land
For that
Council.
purpose, your lordship
All right, Mr.
directed-
Sahu. Mr. Sahu, Land Council for the state submits that the affidavit which was supposed to be filed as per the order dated 24/9/2024 by the state is ready, and it will be filed during course of the day, serving copy on the Land Council for the petitioner as well as Land Council for the opposite parties number 1 to 5. Put up this matter in the week commencing from 12th of May 2025. Yes.
Pass that order in review petition.
This is to be passed in the review petition.
Yes.
50 of 2024. Yes. And this should be listed along with the contempt petition number 2547 of 20. Yes.
Item 2.
The item 2 allow some types of instruction about the complaint.
What was the order passed for which this?
My lord, this honorable court dispose of the petition, directing the opposite part number 3 to dispose of the representation of the petitioner under Annex 8 within a period of 3 months.
That order was passed on 27/2/2024.
Yes.
And from the it is to be disposed of within 3 months from the date of production of the certified copy of the order. So when you send the order copy to the
In page 11, 7/3/2024 through registered post.
you have not received any response from the
No, my
opposite party contender.
no, my
Hmm?
The order for the
Hmm.
within order. What was the prayer in the report? Yes. The second paragraph was about.
Hmm. This contempt petition has been filed by the petitioner Manjula Sandha for non-compliance of the order dated 27/2/2024 of this court, passed in WPC number 42842 of 2023, in which the direction was issued to the opposite party number 3, land acquisition officer, office of the collector, district magistrate Ganjam, to consider and dispose of the representation filed by the petitioner and to pass appropriate order as early as possible within a period of 3 months from the date of production of the certified copy of the order. The Land Council for the petitioner submits that as per the said order, the copy was sent to the contemner, opposite party on, what is the date?
7/3/2024.
May I submit one thing?
Yes.
Lordship received the order dated. OP3 is to consider.
Huh?
OP3 is the land acquisition officer. But
Yes.
he has submitted the report to collector and collector is the contemner here.
Was the OP3 there?
OP is the land acquisition officer.
Both the
Land acquisition officer and
collector
for the collector.
collector is the land acquisition officer.
Hey, who was the opposite party number 3 in the writ petition?
Land acquisition,
Land
land acquisition officer, office of collector.
collector.
The collector is performing the duty of land acquisition.
No, that is a misconception.
No.
Collector cannot.
Land acquisition officer is the person against who was directed to dispose of your representations, and he is opposite party number 3. But you have not arrayed that land acquisition officer as a party, but you have arrayed Divya Jyoti Parida, IS collector from district magistrate, who was the opposite party number 2 as the contemner. There was no such direction to dispose of the representation by the collector. It was directed to be disposed of by the land acquisition officer.
My humble sense, the collector is the land acquisition.
The council, the order is very specific. If any contempt has been committed, that is committed by the opposite party number 3. So the
Opposite party number 3 in the writ petition is land acquisition officer
in the office of
the collector.
so he is not, the collector is a different and land acquisition officer is a different.
Yeah.
In the office of the collector.
In land
Who is the
acquisition,
LAO?
in land acquisition act, the land
Collector is
acquisition.
But
No,
your parties, you have implemented land acquisition officer.
The order
In
is
the
very
office of-
specific that it is to be, the order is to be produced before the opposite party number 3. And you have not produced the order. The copy of the order was sent to the collector. Neither, so in terms of the order of this court, you should have submitted the copy to the land acquisition officer before whom your representation is pending. But see your postal receipt that indicates that it was addressed to the collector from DM.
Your lordship kindly glance the notice which was sent to the petitioner, the LA collector.
We have to see that whether there has been non-compliance of the order by a particular person. So the very person who was directed to dispose of the representation.
Come to your contempt petition. What have you said?
Yes.
First paragraph. Just see first paragraph. You yourself have said that the direction is made to opposite party number 2.
That's a wrong.
It's and opposite party
There is
number
an
2
error
is
of
the correct.
record. No direction was issued to opposite party number 2. Rather, the direction was issued to
Just
opposite
the-
party number 3.
First paragraph of your contempt.
It's a totally misconceived.
The case of the
Application.
petitioner was heard on such and such day. After hearing the case, the Honorable Court disposed of the petition by directing the opposite party number 2 to consider and dispose of the representation. It was indeed to opposite party number 3.
Take down all the clear.
Permit to withdraw to weekly for that.
Stop. But we find that the order was very specific, that the opposite party number 3 was directed to consider and dispose of the representation filed by the petitioner within 3 months from the date of production of the certified copy of the order. However, the copy was never sent to opposite party number 3, but the postal receipt indicates that the copy was sent to collector district magistrate Ganjam, and collector district magistrate Ganjam has been made the contemner opposite party. Since stop. In the contempt petition, in paragraph number 1, it has been stated that this court directed the opposite party number 2 to consider and dispose of the representation filed by the petitioner, which is an error of record, since no such direction was issued to the opposite party number 2 to consider and dispose of the representation, and the copy of the order was not sent to opposite party number 3 land acquisition officer in the office of the collector cum district magistrate. We are of the view that this contempt petition is totally misconceived. At this stage, the land counsel for the petitioner seeks permission to withdraw the contempt petition. This is disposed of as withdrawn. Yes.
With liberty to.
But liberty is always there.
Next.
Item 3.
Email in terms of order dated 7/4/2025 to comply. To pray some time for compliance, because the period of for disengagement to reinstatement has to be regularly, services has to be called for from different station. I pray for some time.
Just a minute, just a minute.
Such as there are.
Violation of the order. You see, first the order was passed in the writ petition.
Thereafter contempt.
Then
Then it is
one
acted
contempt was
finally
filed.
also. That-
And you approach the Supreme Court
Yes.
in the SLP,
Yeah.
and the SLP was dismissed.
Aye.
And the copy of that order passed in the SLP has also been filed.
Aye.
And that has been taken on record. So even though in the writ petition, there was an order in favor of the petitioner, and your attempt to challenge that order has not yielded any fruitful result in the Supreme Court, and in the first contempt that was disposed of, what is the order that was passed in some time was granted to comply the order?
3 months time.
3 months time. So you are not doing it.
We are concerned. My lord, only because I have talked, because the service books has to be regulated from different section.
Whatever it may be,
We pray 10
this
days
is the
time.
order dated, order of the court is dated 11/5. No, what is the order of the court in writ petition?
That is on 19/4/22.
So 19/5,
19/4/2020.
19/4/2022, order has been passed by this court, and your additional chief secretary is unable to comply the order. Appear through virtual mode. Ask her to appear through virtual mode. The Land and Council for the state seeks some more time to comply the order of this court passed in WPC number 6277 of 2024, order dated for the 19/4/2022, passed by this court in WPC number 6277 of 2014, WPC number 6278 of 2014, and WPC number 6279 of 2014. Stop. Needless to say that even though the order was passed in favor of the petitioner and the state approached the Honorable Supreme Court in SLP number 16485-16487 of 2023, but the SLP was dismissed on 5/12/2024. Even the first contempt petition filed by the petitioner in contempt petition number 2553 of 2023, order this court granted time for 3 months to comply the order from the date of communication public production of the certified copy of the authenticated copy of the order by the petitioner. Thus, it is clear that even though more than 3 years have passed from the date of the first pronouncement of the order by this court, in the writ petitions, the petitioner is yet to receive the benefits, let the opposite party, opposite party number 1 appears. Who is the opposite party number 2?
Two will be better.
Huh?
Engineering chief will be better is the.
Acha. Let the opposite party number 2, Bhaktaranjan Mahanti, Engineering in Chief, Water Resources Department, Sector Southern Bhubaneswar, appear to virtual mode. Day after tomorrow, Prabhu. Today is 2nd of May 2025. At 10:30, a free copy of the order be handed over to the Land and Council for the state for compliance. Yes. For passing necessary instruction to them, compliance.
Lordship may play that order maybe in the course of the day so that I.
Yes, that will be handed over to you.
Item 4.
Lordship, in item number 4, the petitioner will approach this honorable court in the defiance of the order dated 18/4/2024 in Annexure 1, your Lordship.
What order was passed?
Lordship, the operative part is in page number 15, your Lordship, para 6. Learned counsel appearing for the petitioner contained that after receipt of the counter affidavit, he has obtained the guidelines issued by the Government of Orissa Revenue and Disaster Management Department on 27 January 2016 with regard to direct purchase of private land through bilateral negotiation for infrastructure and industrial projects. He produces the said guidelines before this court. The same be kept on record. In view of such position, this court disposes of this writ petition directing the opposite party authorities to make direct purchase of land in question in conformity with the guidelines 27/1/2016 issued by the Government of Orissa Revenue and Disaster Management Department and pay compensation to the landowners as expeditiously as possible, preferably within a period of 4 months from the date of communication or production of copy of this order. In Annexure 2, your Lordship, copy of order was sent to the opposite parties.
On what date?
Lordship, already communicated on
25/4/24.
Lordship.
You have not received any response.
In the meantime, the already file has been processed, matter has been placed before the competent authority and the amount has been sanctioned. We may allow 10 days time to file the complaint.
This contempt petition has been filed by the petitioner Amresh Das for non-compliance of the order dated 18/4/2024 passed by this court in WPC number 5364 of 2024. The operative portion of the order reads as follows. Quote paragraph number 7. Land Council for the petitioner submits that in pursuance of such order, the petitioner made the necessary communication with and produced the copy of the order on 25/4/2024, which would be evident from Annexure 2. But till date, the order has not been complied with. Land Council for the state on instruction submitted that the file has been processed and he may be granted 10 days time to obtain up-to-date instruction in the matter. Put of this matter on 13th of May 2025.
Item 5.
Adding the opposite number of 6 manner, was passed through into the idea Mr. 7 manner.
Have you filed that application?
I
filed.
Hmm.
He is to be added as opposite party number 6.
Yes.
Okay. You have given a copy to the Land Council for the state. So, Mr. Mahanti, he has challenged the order passed by the senior manager HR under
By
Annexure 7.
IFCO.
So he was not arrayed as a party, so that is how he took time on that day to file an interim application to array that senior manager as opposite party. That is his prayer now in the interim application. So let it be allowed.
Yes.
The interim application number is 6636 of 2025. There is an application for adding Chief Manager HR IFCO Paradeep as opposite party number.
The senior member. First of the senior member.
Mr. Council, look at your prayer. See your prayer in the interim application. Your prayer is to amend the cost title by inserting so and so as opposite party. Senior manager is not there, it is chief manager. You withdraw it and file a better application. No, that cannot be. Your prayer is something different. And how it is to be, you will be permitted to amend the cost title unless you make a specific prayer that this man is to be allowed to be implemented as opposite party number so and so. And petitioner may be permitted to also amend the cost title. This should be the prayer. It's not that your direct prayer is to amend the cost title. First, you are to seek permission to allowing that man to be added as an opposite party and also for amendment of the cost title. IN number so and so, this and so on. Land Council for the petitioner seeks permission to withdraw this interim application to file a better one. Permission is granted. Yes, disposed of as withdrawn.
Item 6.
Item 6 the person.
Yes,
Item 6 the chief manager.
the same mistake.
Mistake no.
अच्छा ठीक है जी.
Chief manager.
Inserting chief manager HR. So let us see the order. All right, this is right. IN number 6638 of 2025. This is an application filed for adding chief manager HR IFCO Paradeep as opposite party number is to be opposite party number 6 as opposite party number 6. What does it mean? By inserting so and so chief manager as opposite party number 6 prior to opposite party number 5 means how a person can be added as opposite party number 6 prior to opposite party number 5? Opposite party number 6 comes after opposite. Are you not reading this? Whatever they are preparing, you are just asking them to file. All regular. जल्दी को छोड़ दूं. Since the later dated 16/5/2023, which has been challenged in this writ petition, has been issued by Chief Manager HR. Later dated so and so, Annexure 7, which is challenged, has been issued by so and so. The Land Council for the state has no serious objection. Accordingly, the Chief Manager HR IFCO Paradeep is permitted to be impleaded as opposite party number 6 to this writ petition. IA is disposed of. Land counsel for the main writ petitioner shall file a consolidated cause title inserting the name of newly added opposite party, serving a copy of the same on the Land and Council for the state. Within by next week, put up this matter. The week commencing from 12th of May 2025. Yes.
Item 7.
Level 7 482
File a memo. This writ petition has been filed with following prayer again. Land counsel for the petitioner files a memo. Withdraw the writ petition. Memo is taken on record. Writ petition is disposed of as withdrawn. Yes. Mr. Swansol, Land Counsel, is present for the union of. You don't want your presence to be recorded? Opposite party number 1. You are Mr. Darpanaran Patnaik. Or you are the Central Government Council?
Senior Panel Council.
Senior Panel Council is present. Yes. Next.
Item 8.
It's a challenge the order dated 6/2/2025 at Annexure 6 at page 55, passed by Lawrence Central Administrative Tribunal, in which his prayer has been negated by Corvus filing. The fact of the case, the petitioner initially
Which is the order you are challenging?
that is 6/2/25 at Annexure 6 at page 55.
Have you given a copy to the Union of India?
What happened in the case?
Yes, we have received the advance copy.
And he was allowed first SCB, second SCB, and also third SCB. But that post was a merger with the other post with effect from 27/2/2015. So he prayed. So third MSCP became.
Your prayer has been noted down by the Land and Central Administrative Tribunal in page 2 of the order, right?
Yes, madam.
So all the prayer has been disallowed, or any of them have been allowed?
Disallowed. Main prayer was you have to be allowed the grade pay of 4,200 with effect from 27/2/2015.
So
the date of a merger of the post.
Just a minute.
With the other post.
Union of India filed the counter affidavit.
Yes, madam.
What was their stand?
Then, your lordship kindly see para 4 of their judgment at page 59. That misconceived that I wanted to dispel with retrospective effect, but my prayer is from 27/2/2015 from the date of merger. That I lordship at page 59.
Now, you have annexed also the original application and the counter affidavit.
Yes, my prayer.
You can come to the operative portion, paragraph number 6.
Yes, my.
Please place it.
Para number 6 of the
order, impugned order.
Yes, my. We have also considered the grievance of the applicant from another angle to find out as to whether he will be entitled to the benefits claimed in this way. He was appointed as a milk recorder on 15.
What is milk recorder?
Milk recorder.
कौन तां काम कौन?
क्षीर जो आसे तादरे से सब ताको चेक करिवे.
Eventually check करिवे. Bureaucracy नहीं.
Government of India, that is the.
सही नहीं.
What is that duty? I was just asking you.
That milk record जो क्षीर आसे से क्षीर को से सब मापिवे केते क्षीर ठीक रहछि कोकरा क्षीर ताकर ठीक मेजरमेंट दे दिया है नि से क्षीर करी हेला तयारी करा जाए. मिल्क ऑफ दैट इज द गवर्नमेंट ऑफ veterinary and
all right. Milk recorder or certificate.
Milk recorder and other posts were there. On
all
yes, ma'am. The SCB scheme came into effect 99. Therefore, applicant brought granted first financial obligation under SCP in the year 99. Second one in 2003 to the net Iraqi in the promotional cadre. He completed 30 years of regular service with effect from 15/1/2006. Thus, he was granted third financial obligation under MSCP with effect from the cut-off date, that is on 1/9/2008 to the next grade pay 2,800. Thus, an employee working as a milk recorder with the grade pay 1,900 subsequent to merger will be entitled to financial upgradation MSCP to GP 2,000 Then second financial upgradation under MSCP to grade pay 2,400, and the third financial upgradation under MSCP grade pay 2,800, which has already been granted to the applicant. Therefore, the applicant is under misconception that by of a merger of a post of a mill recorder with the LDC of 1900, he is entitled to third financial obligation to grade pay of rupees 4,200, and hence case was right is rejected, requiring no judicial interference by the tribunal. Your Lordship, kindly see their document that annexure A by 3 to the counter at page 46.
46.
Yes, ma'am.
Yeah.
All the posts, your Lordship, kindly 6, Ramesh Chandra Diary Clerk, all the posts merged to one LDC cadre. There, your Lordship, kindly see second MSCP.
No, where is your name?
My name is S.K. Sahoo 7.
Acha,
The sixth, my Lordship, kindly see Ramesh Chandra Diary Clerk, annexure 1, as per annexure 1 to the counter, all became merged to one cadre. And 1 2, that is LDC. Your Lordship, kindly have a mark. That is the fifth column. His second MSCP is 2,800. What you got it? But I was allowed third as a 2,800. When the 2,800 as per second CPUC, when 2,800 is second, my grade pay would be 4,200. Your Lordship, can come to again bottom, another case is there. Third MSCP, another mini bus driver, he was given 4,200. So grade pay is attached to the post and the scale. So scale was a 5,200 to 20,200. There, the third grade pay will be 4,200. This is the document they have filed there. And what they said is, what the Colonial Tribunal said, that my demand or my prayer with retrospective effect, that is has been mentioned in paragraph 4 and 5. That is not my prayer. My prayer from the date of a merger, that is 27 to 2015. 27 to 2015, there is no third MSCP for 2,800. As your Lordship law, you will settle that all this scale and grade pay is attached to the post. A person discharge the duty against the post, he is entitled for that post. And this is only my submission. And your Lordship will see paragraph 4, what they said, and 5, they said that therefore this cannot have a retrospective effect. I have never applied for retrospective effect from the date of my merger, 27 to 2015, and also after 7 months I have retired. So my pay may be refixed, taking into my grade pay. This is my prayer. Not a tribunal. From that as if my demand is for, or my prayer is with the retrospective effect. That as paragraph 4 and 5 it has been clearly mentioned.
May I clarify, my lord?
Yes, Mr. Pari.
Lordship may come to the page 37, counterfeit filed by the Union of India before the Law and Central Tribunal. Let us start from page 36. And I am coming to the relevant page 38, but it's the paragraph, it starts from paragraph 3, starts from page 37.
Yes.
Then Lordship, I am just coming to page 38. May I read, my lord?
Yes, of course.
Further, insight into the applicant service record reveals clearly that she is Shantanu Kumar Badponda. The applicant joined the bill recorder on 15/1/1976, as admitted also by the applicant at page 3 of the original OA, has retired on 30/4/16 from the same post without any promotion. Therefore, according to the financial progress schemes of the Government of India, that is SCP such and such, MSCP modified assured scheme, the applicant has already been provided 3 financial benefits in the form of first SCP during 99, second SCP during 2003, annexure RB2, followed by the third MSCP during 2008, annexure RB3. Thereby, is satisfying the very basic concept of MSCP, which is aims to be provided at least 3 financial benefits during the service career, that is at 10 years, 20 years, 30 years respectively. Even if there is a no promotion of the incumbent during the service career. Hence, there is a probably no further scope of providing another higher financial benefit of GP 4,200 after rupees 2,800 as per the provisions of the MSCP scheme, and hence both the way such and such MA arising out of the scheme are not tenable and should dismiss the order of the petition. That means 2 SCP has been given, 1 MSCP has been given. That means they exhausted the benefits. If a person is more than 30 years, then he is entitled to MSCP which has already been paid.
Your reply may be correct if the post would not have been merged. Once the post is merged,
My lord.
then the situation is different. That's what he says.
He is pointing out that, where he was pointing out that chart.
That is the annexure A by 3 of their counter at page 46.
40.
In page 39.
And that time 2008, right here I was allowed 2,800. That was my grade pay at that time. When the post was a more to higher scale or higher post, and I have been discharged my duty, I am entitled to that
When the
scale.
post was merged, date of merger?
27/2/2015. That is at annexure 1 to my.
You got MSCP 1?
Then mill recorder and that post all are.
When you got date?
My lord.
Which 2008 you got?
2008, I have got the benefit of the third MSCP. What was at that time, according to my post, I was allowed 2,800. But that post on most to the one scale that carries 4,200 as the third MSCP. I wanted that scale from that date of a merger, 27/2/2015. That your lordship kindly see page 10 at page 21, annexure A by 1, that is order of a merger. All the posts, lower divisional clerk, Hindi, diary clerk, store clerk, lower divisional clerk, all became to one.
Came to group C.
Group C.
And group C is the Kuchi 4,200.
That they have given their calculation, annexure 3. That is second MSCP 2,800 and third is 4,200. And I have been shown as the third as the 2,800, whereas Ramesh Chandrapana diary clerk shown as the second as the 2,800. That is discrimination.
That is explained in page 39, second paragraph. The second paragraph, that is clarified, my lord. Finally, next paragraph, I am just reading. Finally, as put forth by the applicant in his original way, number 228 of 2019 at page 8, under the clause 8, that the grade pay of 4,200 in PV number is 2 is requested to be allowed to be paid to the applicant with effect from 27/2/2015, because this was, my lord, is put this particular date, that's why 27/2/2015, because this was the effective date of merger of the milk recorder post with the lower division clerk LDC, and because the actual of the promotion post of LDC is UDC for division clerk with GP 4,200.
2008 all the 3 benefits were given. 2015 merger has been.
And this post are same. That post and LDC is equal.
Their case is by 2008, all the 3 benefits you have already got exhausted. And in 2015, a merger has taken place. So you are claiming the merger benefit into the MSCP retrospectively.
Not retrospectively. I have never. Your lordship,
actually, merger has taken place in 2015. Then,
so my prayer from 27/2/2015 as because from 27.
All the three benefits has already been exhausted in 2008.
Yes, that has been given.
Then
my submission is that your lordship kindly appreciate one thing. I don't pray for the another MSCP, same MSCP, third MSCP, which was given at the rate of 2,800. That is that no more existence after 27/2/2015, as because after merger of the cadre or post, that third MSCP became 4,200. So that's why my prayer is that I am entitled to the benefit from 27 to 2015. But the Lord Tribunal committed error that as if my prayer is with retrospective effect. Since it has no retrospective effect, I cannot be allowed the benefit. That is the finding of the Lord Tribunal. But my prayer from 27 to 2015, as because from that date, and even if the mail record or post, that the grade is no more existence. That is from 27 to 2015.
ସେଇ ଦିନରୁ ମତେ ଇଏ ହଉନି grade better. Your claim is only confined
Yes,
to
confined.
27 to 2015.
I have also made prayer from date of merger. That is
All right. And this writ petition has been filed by the petitioner Shantanu Kumar Barponda, challenging the order dated 6/2/2025 passed by the London Central Administrative Tribunal, Cuttack Bench, Cuttack in OA number 260/00/228 of 2019. It appears that the petitioner filed the original applications with prayer to allow him the grade pay of rupees 4,200 with effect from 27 to 2015 towards third financial upgradation under MSCP, and accordingly to refix his pension and pensionary benefits upon his retirement with effect from 1/5/2016. The Union of India filed their counter affidavit, and the London Central Administrative Tribunal, in the operative part of the order, has been pleased to hold that the petitioner was working as a milk recorder with GPRS 1900. The petitioner was appointed as milk recorder on 15/1/1977, and the SCP came into effect from 1999, he was granted first financial upgradation under SCP in the year 1999, second one in the year 2003, and the next hierarchy in the promotional cadre after he completed 30 years of regular service with effect from 15/1/2006. And he was granted third financial upgradation under the MSCP with effect from the cutoff date 1/9/2008 to the next grade of pay of rupees 2,800. Operative portion dekhi thik se kari without correction. It was further held that since an employee working as milk recorder with GP of rupees 1,900 subsequent to the merger will be entitled to the first financial upgradation under MSCP to rupees 2,000, and then second financial upgradation under MSCP to grade pay of rupees 2,400, and third financial upgradation under MSCP to the grade fee of rupees 2,800, which has already been granted to the petitioner. Therefore, the petitioner is under misconception that by virtue of the merger of the post of milk recorder with LDC GP 1900 is entitled to third financial upgradation of grade pay of rupees 4,200. The learned counsel for the petitioner submitted that finding of the learned tribunal is illegal and not sustainable in the eye of law. It is argued that the claim of the petitioner is for extending the benefit of equality on the eve of merger of cadre, and the petitioner prayer was for the benefit with effect from the date of merger of the cadre. But the learned tribunal committed gross error, holding that the order of merger is not with retrospective effect. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. No notice be issued to the opposite party. Number 4, the learned counsel for the Union of India accepts notice on behalf of you. You will appear for the OP 1 to 3.
Yes.
Opposite parties number 1, 2, and 3. Extra copies of the writ petition be served on the learned counsel for the Union of India by next week. List this matter after 4 weeks counter affidavit, if any, so the writ petition we filed in the meantime. Yeah.
Item 9.
Okay, Lord. Here, my lord, the petitioner has been petition with a prayer to direct the opposite party number 2 to resolve the dispute under section 30 of the Land Acquisition Act, 1894, my lord. The petitioner's land was acquired, my lord.
Yes.
But what has happened, my lord? In view of the fact that, my lord, their lands were fraudulently recorded in favor of opposite party number 4 and 5, my lord, they made the representation before the LAO, that is opposite party number 2, on dated, my lord, 12/5/2023, under Annex of 4, my lord. After receipt of that representation, the opposite party number 2 issued notices to the petitioners to appear before his court on, my lord, 1/12/2023, my lord.
Annex of 5.
Annex of 5.
Yes.
They appeared, my lord, before the land acquisition officer. But the land acquisition officer expressed his inability because the ROR stand recorded in favor of opposite party number 4 and 5, my lord. Thereafter, my lord, the petitioners again submitted another representation on the Annex of 6, my lord, reiterating their grievance therein on 4/7/2024, my lord. And they prayed for a reference to the competent civil court to adjudicate their claim, my lord. In spite of that, my lord, the land acquisition officer did not pass any order on their representation. Thereafter, my lord, the petitioners applied on the RTI Act. Your lordships may kindly turn to page 51, my lord. This is Annex 7, my lord. This is the RTI information received on 18/12/2024, my lord. And in page 51, my lord, it is written that held off. The compensation amount was not disbursed in favor of anybody till, my lord, 18/12/2024. Thereafter, my lord, the petitioners again applied under RTI Act, and that information was received on 29/1/2025, wherein, my lord, in page 54, my lord, held off has been stopped down, my lord. The lordship will find that, my lord, at page 54, my lord. That means they have already disbursed the compensation amount in favor of opposite party number 4 and 5, my lord.
The background of the case is like this. One Ananta Naik was the common answer. I have given the
What we will do?
These are disputed facts. We will decide if the petition.
That is, you have, my lord, the land acquisition officer should refer the dispute to the competent civil court for entitlement, who are entitled to get.
Perhaps my friend is not brought to the previously for a different land, the such type of dispute was there, and the matter was referred to the referral court under section 30 of the Land Acquisition Act. In the referral court, it was held that the opposite party number 1, 2, and 3 are not entitled. That means here the opposite party, they are not entitled for get any. That was not brought to your lordship's notice.
Yes, sir. That is in respect. That is in respect of another piece of land. Matter number 77, my lord. And in that reference court, my lord, the referral court has clearly held that, my lord, the present opposite party number 4 and 5 are not entitled to any compensation amount.
That is in respect of another land.
Another land.
Yes. But what about this land?
This land, my lord, the
ROR is not recorded in your name. So how will you get the compensation amount?
That is why I want that my case should be referred to the competent civil court, my lord.
No. Who is to be the person whose name are recorded in the record of rights? If that land is acquired, so they are entitled to get compensation. So plain and simple question is that when the ROR shows that it is recorded in the name of ABC, let us say you are XYZ. So how compensation will be paid to you?
No, in the award, my lord, all the parties, all the parties' name are there.
Where is that award?
In the notice, my lord. Notice, that is
notice at page 5.
Page annex of 5, page 46. Notice was issued to all the parties.
Your name, this petitioner's name is there?
Yes.
Hojraj and Tularam, petitioner number 2.
Hojraj Barik and Tularam Barik.
So then you submitted the representation?
Yes, my lord. Under annex of 6, my lord.
No, if notice has been issued, the date was fixed to appear on 1/12/2023.
my lord.
So what was the problem? Why you did not appear on that day?
I appeared, my lord.
Yeah.
But the LAO did not pass any order and simply expressed his inability on the plea that, my lord, the ROR stand recorded in favor of the opposite party number 4 and 5, my lord. ROR does not create right or extinguish title.
No, it's all right. In the representation which you filed under Annexure 6, where is the averment taken that in pursuance of the notice dated 22/11/2023, you appeared?
Yeah, I have taken that averment, my lord. Lordship may hand down to case, my lord.
No, not that is. That is not there.
I have taken that averment.
No, averment in that representation, which you submitted before the land acquisition.
Representation, there is no such averment.
In the representation,
yes,
there is no averment.
Representation was made on 4/7/24. It is almost 6 months after. And in the notice, you are supposed to appear on 1/12/2023. Your claim is now that you on 1/12/2023 you appeared before the concerned authority, but no order was passed.
Yes,
right? And you are not given that compensation amount. কারণ তাদের লেখা হয়েছে যে জমি অধিগ্রহণ করা যাইଥିଲା বর্তমান সুহাংশু তো নিমন্তে অনুগ্রহ রাশি প্রদান করা যাଉଛି সেই অনুযায়ী ଆପଣଙ୍କୁ ইয়ার ଯୋଉ ଧାର୍ଯ୍ୟ ହୋଇଛି ଉପରୋକ୍ତ ଅତିରିକ୍ତ ଅନୁଗ୍ରହ ରାଶି ପାଇବା ନିମନ୍ତେ ଆପଣ ଭୂ ଅର୍ଜନ ଅଧିକାରୀ ସୁନ୍ଦରଗଡ଼ କାର୍ଯ୍ୟାଳୟରେ 1/12/2023 ତାରିଖ ଦିନ 11ଟା ବେଳେ ଆପଣଙ୍କର କରାଯିବ ଆପଣ ସମସ୍ତ କାଗଜ ପତ୍ର ସହିତ ଆସି ଉପସ୍ଥିତ ହେବେ So what is the proof that on that day you appear before the concerned authority and it seems that 6 months thereafter you filed a representation to the land acquisition officer and there you prayed for referring your case to the civil court for determination.
My lord, Annexure 7 proves that, my lord. Annexure 7 proves that fact, my lord. in view of the fact that, my lord, the entire compensation amount was held up, my lord, till, my lord, 18/12/2024, my lord. That is why I again want to bring your lordship's notice to page 51, my lord. Running page 51. A representation debar means a position.
All right, suppose let us say that the amount has been paid
my lord,
to somebody illegally.
My
According to you, it is illegally, and even though notice was issued in your favor, then if the civil court decides that the payment was made illegally, and so that amount can be recovered or not.
Yes, well, it can be recovered.
So why are you not approaching? Why we will adjudicate all this disputed thing? Where it is scope for that evidence is required. You have to file the documents, how you are entitled to get, because the ROR does not indicate your name. On what basis you are claiming that you are entitled to get compensation? All those things are to be brought before the appropriate court, and notices will be issued. And ultimately, if the court holds that even though your name is not there in the ROR, you are entitled to a part of the compensation amount, then appropriate order will be passed, and those persons who have received the amount, they will be asked to refund a part of it so that it will be paid to you. What this High Court will do in such a in this writ petition?
In such a scenario, my lord.
Yeah?
My respectful submission before your lordship should be, my lord. Your lordship may direct the petitioner to approach the civil court or direct the LEO to report.
Why should we direct? You have a right to do that. See, if there is a dispute in apportionment, Section 30 provides that the collector may refer it to the civil court. If the collector doesn't refer it and the amount is paid, then if you are a claimant, a civil suit lies for the purpose of recovery, because these are disputed questions of facts to be determined by a civil court. A writ court can't do anything. So you approach the writ court wrongly.
This simply prays to direction to the land action officer to refer the matter to the civil court under Section 30.
But the disbursement has already been done.
Will decide whether the petitioner
and the expression used there is may. Just see Section 30. The collector may, if collector thinks that there is a dispute, then he will refer. If the according to collector there is no dispute, disbursement has taken place.
In respect of another land, my lord.
Then recovery lies.
My lord, in respect of another land, my lord.
All right. You approve the appropriate part.
Yes, another order has been passed by the division bench of this honorable in respect of same parties, my lord.
The writ petition has been filed by the petitioners Tularam Badhi and Gujraj Bari. With a prayer for a direction to the opposite party number 2. From our land acquisition officer Sundargarh to refer the dispute regarding payment of principal award amount, including the ex gratia compensation amount for adjudication, to the competent civil court under Section 30 of the LA Act. The land counsel for the petitioner submits that even though the petitioner along with others were issued notice, petitioners ka din. Where is that notice? Under Annexure 5. Under Annexure 5 to appear before the opposite party number 2. Opposite party number 2 to receive the compensation amount, to produce the relevant documents for the purpose of receiving the compensation amount, but ultimately the amount was not paid to the petitioners, but it was paid to the opposite parties number 4 and 5. 4 and 5. However, he submits that he further submits that the payment of the compensation amount to opposite party number 4 and 5 is illegal. Stop. He further submits that though a prayer was made by the petitioner under Annexure 6 before the opposite party number 2 to refer the dispute to the civil court under Section 30 of the Land Acquisition Act 1894 for determination of the person who is entitled to get the compensation amount, but the same has not been done. Stop. There is no dispute that Section 30 of the LA Act, which deals with dispute as to the apportionment, states that if the compensation amount has been settled under Section 11 and any dispute arises to the apportionment of the same or any part thereof, or as to the person to whom the same or any part of thereof is payable, the collector may refer such dispute to the decision of the court. So you have not, it should have been filed before the collector. Why have you filed before the land acquisition officer?
Land acquisition officer cum collector is the element.
That you have not mentioned. You have, the collector is opposite party number 3. Land acquisition officer is simply
office of the collector.
No, your representation is not addressed to the collector.
Your representation is not made to the collector. So the statute says that, and if the land acquisition officer is also cum collector so and so, you should have mentioned it. So your representation for, you see, it is simply to the land acquisition officer.
That has been received, my lord. That has been received, my lord. Page 47. In the bottom. Left hand.
Be that as it may, since the compensation amount has already been disbursed in favor of opposite party number 4 and 5, and there are provision under law to approach the appropriate forum and by the petitioners to substantiate their case for recovery of the compensation amount paid to the so and so opposite party number 200. The petitioner seeks remedy to withdraw this writ petition to seek appropriate remedy in accordance with law. Allegedly played for them to the opposite party number 4 and 5. And moreover, since the disputed question of facts are involved in the writ petition, we are not inclined to sponsor it. At this stage, the land counsel for the petitioner seeks permission to withdraw this. Then permission is granted, disposed of as usual.
Item 10.
May I please interrupt? Plus, this writ petition emanates from a land acquisition proceeding in the year 2006, my lord, in the district of Jagatsinghpur, and this is the second round of litigation. The present petitioners are being represented by their society. It's a registered society, by the president. The second round of litigation, and their grievances were limited, my lord. Here, what has happened, my lord? In 2006, the land acquisition proceeding was initiated. 2008, the compensation has been paid, but only limited question of displacement.
RR benefit.
My lord,
RR benefit is not granted.
No, RR benefit has also been given because they also, in lieu of the employment, they have taken money. The only limited question here is regarding displacement, my lord. For that, I'll take a lordship to only 2 annexures, which will clarify the situation. Is annexure 4 at page 29. Here, what has happened, my lord? The land has been acquired by assault method. What they have done now, instead of displacing the people from here, though there was a proposal for displacement which could not be affected, could not be given effect to. The villages are still there. But now what the company has done is construct a huge boundary wall all around the villages, and then it's like become like a open prison for them, man. There is only a small 7 feet or 8 feet road for ingress and outgress, and there whatever I'll take your lordship
Is
to
it
the
a
mind.
PIL? This is a PIL.
No, not a PIL. This is
You just see the petitioner is Ramo Surakya Samiti.
representative capacity, my lord. He has filed his writ in the representative capacity.
So what do you want now?
They are actually aggrieved. They are actually aggrieved. They are the villages of Handia. Your lordship.
No. What is the, what do you want now?
My lord, I want that your lordship may come to Annexure 7, my lord. Kindly peruse Annexure 7. This is the second round of litigation. Pursuant to the direction of this honorable court, a meeting was conducted. The collector presided the meeting, and these were the points that are discussed. Now, your lordship will see decision taken. Uninterrupted boundary wall constructed by the contractors. My lord, I am reading from the third paragraph. Decisions taken. Uninterrupted boundary wall construction by the contractors engaged by AMNS India will be completed without any opposition or obstruction from the local villages. My lord, we had nothing to say in this because we are the receiving it, so we had nothing to say in this. But the fact remains, boundary wall is being constructed all around. And what is the grievance, my lord, is the next. Incomplete developmental works shall be completed by the company, like installation of another RO for drinking water purpose, imparting training to local women for providing livelihood support by setting up stitching machine units, completion of another wood bridge, leveling of volleyball ground at the identified site. Third, drainage facilities of rainwater shall be provisioned by the company alongside boundary walls in order to protect the.
This was the settlement. This was the
settlement.
And go before collector tell.
No, my lord, this is the minutes of the meeting that we held with the collector. But now nothing is
collector
done.
Collector to implement it.
No,
we are not going to implement.
This is in, your lordship will see, this is in January 2025. Till date, my lord, the construction of the boundary wall is going on, and the villages are not in a position to oppose.
Uninterrupted, that will go on. But if you have not availed these facilities which has been discussed in the meeting, you have to make a representation.
The petitioner has not filed any document. That such decision has not been taken up.
But you have, see,
it's not required.
Madam, you have to go to the collector and tell all these things. Before you have everything is agreed and nothing is given to us.
My lord, our only grievance is, my lord, your lordship is on what basis?
You tell me it is at best it's a kind of a contract. Can a read court enforce it?
No, it's not a contract.
It's kind of a contract. It's understanding between.
Where displacement would have been taken place, but they have not been displaced.
It is an understanding between you and the other party in the presence of collector. Can we enforce it?
Well, this understanding we had to come to a conclusion.
But can we enforce it in writ jurisdiction?
File your
prayer before lordship. The lordship may call for a report from the state government as to what has been done, my lord. That will suffice.
File your representation if you are.
It will be done.
Well, because the collector is the authority, he knows about this. Now, despite the fact that it is within his knowledge and is not doing it, that calls for intervention of your lordship.
See, virtually, it's a public interest litigation.
These are the villagers who are personally aggrieved, my lord. They are not. It's not a public interest in the sense like not for any representative capacity, my lord. They are the villagers.
Yes,
they are villagers of Handia who have come before lordships.
This writ petition filed.
My only prayer is, if a lordship calls for a report from the collector as to what has been done.
The Gramya Surakya Samiti, so and so, with a prayer for a direction to the opposite party number 3 to implement all the decisions under Annexure 7 for providing R&R benefit to the villagers of Handia without displacing them. It is the submission of the Land Council for the petitioner that a meeting was held on 8/1/2025 on the issues relating to Vilesh Handia in R&R matter pertaining to the establishment of ISP by Messrs. AM/NS India Limited. And the collector and district magistrate Jagatsinghpur, opposite party number 3 was present in that meeting, and following decisions were taken, quote from 1 to 5.
The AGs of collector this meeting and take.
The learned counsel for the petitioner submitted that though the boundary wall has been constructed by so and so, and there was no opposition or obstruction from the local villagers, but other terms and conditions which were required to be fulfilled as for Annexure 7 have not been carried out. And the collector has not made any necessary direction to the opposite party number 6 to comply the same. The land council for the state submits that if any representation is filed by the petitioner before the collector and district magistrate Jagatsinghpur highlighting the non-compliance of the decision taken as per Annexure 7, the same can be looked into by the opposite party number 3. Considering the submission made by the land council for the respective parties, the petitioners are permitted to make a representation before the opposite party number 3, highlighting their grievances within a period of 1 week from today, along with a copy of this order. On receipt of the same, the collector shall consider the grievances in accordance with law, keeping in view the recitals of Annexure 7 according to the petition is disclosed. Yes.
ସେ ଯୋଉ obstruction ନାହିଁ ବୋଲି କହିଛନ୍ତି ସେଇ ପାର୍ଟ because initially ବହୁତ obstruction ଥିଲା at present person to this
respondent number 6 is a state.
No.
Well,
yes, next.
Item 11.
Yes, item number 11.
I am appearing on behalf of learned counsel of the petitioner, and I seek an adjournment on this matter.
You are for? What is your name?
Sorry, Lord. Sorry, my lord.
What is your name?
My name is Gopal Chandra.
You have got no power.
Yes, my lord. I have been instructed by my learned senior to.
You are an associate of Mr. Vidyadhar Mansingh.
Lordship.
Have you gone through the brief?
No, my lordship.
No.
My lord, can I have a glance to the Annexure 1? And
it's because the swift demise of his elder sister yesterday night.
Yes, so what is the Annexure 1, Mr.?
My lord, there is a dispute between two parties. Specific performance of contract, my lord. The petitioner now seeking a direction to the sub-register not to execute the sale deed.
3912.
Everything will come to this court, and remedy lies elsewhere, not this grievance. You cannot be addressed by this court. We are disposing of so and so, hard Mr. so and so, give the name. This writ petition has been filed by the petitioner so and so. with a direction to the opposite party number 2, sub-register Khandagiri, to consider his grievance dated 25/11/2024 under Annexure 1 within a stipulated time. So on perusal of Annexure 1, it appears that the same is dated 25/11/2024, in which a prayer has been made not to register or execute any sale deed related to the land bearing khata number so and so, plot number so and so, mauja so and so, unit so and so, in favor of any other person until the said agreement is terminated. We are of the humble view that such a prayer cannot be entertained by us in this petition. It is up to the petitioner to seek appropriate remedy in accordance with law. Accordingly, the writ petition is disposed of. Yes, next.
Item 12.
May I please, Your Lordship? Master, can you see Annexure 1, page number 40? It's an ROR recorded in the name of the petitioner's father, Your Lordship. Subsequently, after the demise of the father of the petitioner, the present petitioner shall have mutated the land in their favor. That you will find at page number 24. Mishra Patim Basu, Munmun Nag, Deepak Kumar Basu. Now, what has happened, Your Lordship, is that over the land of the petitioners, some of the portion has been occupied by TPCODL. Now, in the 2010 Your Lordship, there was a land acquisition proceeding. It is at page number 35, Annexure 5, Your Lordship. The purpose of land acquisition was for widening of road. And they have acquired 0.60 decimal of land. But, Your Lordship, the portion which the TPCODL is acquiring, that has never been acquired by the state government for the purpose of TPCODL. Now, in that context, under Annexure 4, I sent a legal notice to the TPCODL that under area 7.540 decimal, we have forcefully occupied it. Either you release me the land acquisition for that purpose, or you vacate that premises, which belongs to me. In this context, Your Lordship, I am also supported by the judgment of the Honorable Supreme Court.
What happened? Ultimately, award was passed or what?
No, Your Lordship.
What is this Annexure 5?
My Lord, award has been passed on the context of acred 0.060 decimal, Your Lordship, widening of road, but not for construction of the TPCODL.
You mean to say that for that construction, some more land has been used?
Yes, Your Lordship.
And for that, you have not been paid compensation.
Yes, Your Lordship.
And you are entitled to get more compensation.
Yes, Your Lordship.
That is your case.
Yes, Your Lordship.
So you are having a remedy available with you. If a compensation which has been paid to you,
my lords,
that is not acceptable to you, and you claim higher compensation, that the matter can be you approach the appropriate authority, and it is to be referred to the section 64, na? 64.
Your Lordship.
Have you approached the authority, collector or not?
No, Your Lordship, I have not.
Then
I have seen that provision, Your Lordship, but the difficulty is that the portion which they are occupying is not coming under that settlement, that acquisition proceeding, Your Lordship.
Whatever it may be, if they have occupied,
my lords,
and they are not giving you the compensation,
my lords,
so that is to be adjudicated. You are to prove it before the authority.
Your Lordship. It is like it.
That authority is that LAR, land acquisition.
Lara.
Lara. All right. The grievance of the petitioner in this writ petition, petitioners, is for disbursement of compensation for forcible possession of the land of the petitioner in terms of the provision under right to so and so 2013, or in the alternative, direction to the opposite party not to interfere in any manner with the exclusive rights and title of the petitioner, and to allow the petitioner to exercise such right in respect of the land in question. The Land Council for the petitioner submitted that though the petitioners have received the award for acquisition of land, which was for the purpose of
expansion of road.
Sera koodi kara road ta code lection ko paragraph re
Peter, that is the lot.
expansion of the road code lection to what use questions.
Annexure 5 is 35.
କୋଉ ଜାଗା ସେଟା
ସେଠି ଲେଖା ହେଇଛି ପରିଯୋଗର ନାମ acquired for widening and
ଲେଖନ୍ତୁ for the widening and ଏଟା କଣ ଲେଖା ହେଇଛି ଜଗତପୁର ଚାନ୍ଦବାଲି ରୋଡ ନା
ଆଜ୍ଞା
widening ଆଉ ଗୋଟେ କଣ ଲେଖା ହେଇଛି ସେଟା ଲାଇଟ୍ ମିଷ୍ଟର ନାୟକ ସେ ୱାର୍ଡ ଟା କଣ ଏଟା
Melody.
You are the council, you should have taken instruction.
Difficult. I'm sorry, Your Lordship, I should have.
Widening of widening of Jagatpur Chandbali Road, but some more land of the petitioner has been acquired.
Strengthening, widening and strengthening, Your Lordship.
Strengthening.
My lord.
Widening and strengthening of Jagatpur hyphen Chandbali Road. Some more land of the petitioners have been used for such purpose, but no compensation has been paid. The Land Council for the petitioner, however, submits that since he is dissatisfied with the amount of compensation and he has alternative remedy under section 64 of the 2013 Act to file written application before the collector for referring the matter to the authority for determination, he may be permitted to withdraw the writ petition to seek appropriate remedy in accordance with law. Accordingly, the writ petition is disposed of, giving liberty to the petitioner to seek appropriate remedy. Yes.
Should be kind enough to have some time frame.
You have to file now the application.
My lord.
There is provision that suppose he does not refer, then you have to directly approach the authority and make a prayer there that ask the collector to refer the matter. So all these provisions are there. So unless you file the application, what is the question of fixing any time schedule for disposal of the? Okay. So we are coming with
Item 13.
May it please your lordship. May it please your lordship. For item 13, this petition has been filed against the order of dismissal of the OA by the Honorable by the Central Administrative Tribunal, wide Annexure 10. Here, the petitioner has filed for a prayer for compassionate appointment, which has been dismissed on the ground that the family was financially stable. So here, without any proper inquiry or any other ground, the only reason for dismissal is the financial stability of the petitioner's family, whereby the family consists of a widow and two minor, were consisting when the father died, who was in the service of the Central Railway. While dying, the only widow was present and two minor sons. One was the age of 6 and one at the age of 3, and an ailing father-in-law. With that, the lady, she managed with her own, with hand loans and depending on her sister's family, she tried to maintain the family. And when the son, the elder son, attained the age of majority in the year 2011, she filed a representation to the department for compassionate appointment.
No, what is the rules for compassionate appointment? Can it be filed at any time after 25 years?
No, your lordship. As per the master's
99 is the death.
Yes, your lordship.
Yes, your lordship. In para
Have you
4
annexed that?
in para 4 of the writ petition, if I may draw your attention, your lordship. In the year 2004, the brother-in-law.
No, you are going to the factual scenario. We are asking you a plain and simple question. Since it is a case for compassionate appointment on the death of a government employee, a railway employee. So, what is that scheme? We want to see that.
You have any rule for
or any scheme?
Yes, your lordship. We have the rule. I'll file the counter, your lordship.
No, let him file that. Have you got any copy of it?
No, as of now, I don't have any copy.
How can you substantiate your case? The sympathetical consideration is secondary matter. Question is that if they have any rules or any scheme for giving compassionate appointment and under during what period it is to be extended.
The exact period has not been determined by any.
How can we know that?
However, I'll
otherwise it can be after 50 years somebody would come.
No.
And
the idea of compassionate employment is only to avoid the vagrants. Okay.
Yes, sir.
And that has to be in consonance with the guideline, whatever you have.
Yes.
You have to substantiate the case. You are falling under the guideline despite that they have not given anything of that sort.
When a direction is to be issued to do something to the opposite party, there must be something statutory in nature. So that on the basis of that, you can claim your right and we can pass necessary directions. So, because as it appears from paragraph 6 of the impugned order, that government employee died in 1999.
Yes.
And the widow was given the death and retirement dues, including full pension in terms of the rule. Now, the question is that at that point of time, there was no claim for any compassionate appointment. So after 25 years, this thing is coming for the first time that give the compassionate appointment to one of the son or whatever. You are the
minor son, your lordship.
The petitioner number 1 is the widow.
Sure, two is
the elder son, Amit Lakra.
All right.
Who is asked.
So the question is that what is that rule or scheme? Can a son who was by then perhaps he was born at that time or not?
Yes, he was 6 years old.
6 years old. So if such a thing is there, suppose there would have been the scheme that if there is a son at the time of death, upon in attending the majority, he can get it. So why are you not filing that scheme?
The factual aspect, I just have to. I will file that.
Like on the Land Council for the petitioner. This writ petition has been filed for so and so by the petitioner for providing appointment to the petitioner by the opposite party in a suitable post by a specific time. It appears that the father of the petitioner number 2 who is also the husband of petition number 1, was working as deputy station superintendent, Southeastern Railways, died in on 17/8/1999, and the petitioner number 1, being the widow, who was in government employment at that time, was allowed death public retirement dues, including full pension in terms of the rules. However, after a lapse of 25 years, the petitioner number 2 claimed for compassionate appointment and approved the Central Administrative Tribunal in OA number 345 of 2021, which came to be dismissed as per the order dated 24/10/2024. When we asked the learned counsel for the petitioner regarding existence of any rule, scheme, guideline for such compassionate appointment, learned counsel for the petitioner 6 times to obtain instruction in that respect, put up this matter on such and such date, adjourn the matter. Yes, next. What is your name, madam?
S.K.Sahoo.
Give the name in name.
Lordship, my name may be recorded.
So and so you are
Milan Kumar, CGC.
give it in writing, and for the Union of India is present over. You also take instruction about the existence of Land Council for the Union of India also submit that he will also take instruction regarding the existence of so and so. Yes, if any, for compassionate appointment. Yes.
Item 14.
Mr.
Yes, sir. At result. Matter land acquisition matter. In 2016, a notification was made for acquiring the land of the petition of Mishra. In 2016, till date, they have not paid the compensation Mishra. In 2019, the petitioner, all the petitioners in Mishra in various institutions approved this Honorable Court. This Honorable Court directed to consider the case of the petitioner is under arrested 1 Mishra and placing your Lordship may see the relevant person, page 16 of the restriction. Page 16 of the restriction, Lordship got it. Accordingly, we set aside the interim order and remit the matter back to the opposite party number 1 and 4 to consider
1 and 4 years.
Yes, consider the grievance of the petitioners in accordance with the provision of the right to fair compensation and transparency in the Land Acquisition, Rehabilitation and Resettlement Act 2013. The authority shall give an opportunity of hearing to the petitioner and shall examine the grievance of the petitioner regarding allotment of an alternative land. In the acquisition notification dated 1/11/2014, it was specifically reflected that the Rehabilitation and Resettlement Scheme 2006 was applicable to the land acquisition notifications for a project widening Bhubaneswar-Sangota Road for the public interest. The petitioner is entitled to benefit under the 2006 scheme. The above exercise shall be completed within a period of 3 months from the date of receipt of the order. Thereafter, no notice was issued, no opportunity was given to the petitioner. The sad
no, you should have filed a contempt petition.
Yes, contempt petition they have not filed yet. Admitted me. So thereafter the petitioner.
Who was the petitioner there? The same people.
Giving different petitions.
No, this is Srimati Binno.
Srimati Binota.
Rasminanda. Yes, petition.
Who are you now?
I'm something.
This number 4 is there.
Various petitions have been filed with us. Basing on this order, all the dispute in the light of this judgment period, all the restrictions are disposed of. So now what happens, after since they sat tight of the matter, the petitioners made a representation under section 101 of the Act. Section 101 of the Act says if the land is unutilized for a period of more than period of 5 years, the land should be returned to the landowners on the legal heirs. Therefore, the representation in my limited parameter, let them
Which
take
provision? Let us see that.
0110, there can't be a direction to that effect.
I have quoted in
01 unutilized land lien obligation.
Paragraph 12 I have quoted here. When any land acquired under this Act remains unutilized for a period of 5 years from the date of taking over possession, the same shall be returned to the original owner or owners of the legal heirs as it is in. So since the 2016, the notification was made for acquisition.
No, a particular jami गुड़ाक देइचंती paragraph number 1, 2, 3 and 4 of your representation, whether those have been acquired and in spite of
that still acquired, compensation has not been paid. On pen and paper that has been acquired. On pen and paper that has been acquired, but no compensation has been paid.
No, where from we got that these are the, where is that notification to show that these are the lands which are coming under that notice has been published and these names.
That judgment, that one section, Annexure 1, the judgment period. The judgment period, you can see they all these.
Judgment it is in respect of one person.
Yes,
and
I have annexed the copy of the book, the other restriction mirror that are referred of in light of these decisions. That is why I only annexed the judgment period.
You see, even Annexure 1, the grievance of the petitioner is that land appertaining to, that is in the first page of the order dated 26/11/2019. It is mentioned in the first page that your plot number is 2775, khata number so and so, was acquired for expansion of the road leading from so and so, right?
Yes,
so the
But as per the
that is mentioned in number 1 of the representation. Took over the possession, earning their livelihood, then you have stated that
one is Urmiliananda.
No. Tara, यार होशी से जो order pass itla in respect of petition number 4. So lady tapal.
That plot number 2775. But in the representation, there are the signature in
on your read would so file ही, of course ताकर किसी ना पा से read or number homework देना.
They कितना read number 8 मिलो. Para 8 रे. I have stated since no action has taken party present petition or other beneficiaries will locate after the annual report by filing various petitions. All the petitions are disposed of in the light of the judgment passed in WPC number 201C3 of 2007.
Read petition.
Para 12. Para 12.
Good.
They can ask for a mandamus on this basis because it is 18 to section 48 of
Want your representation to be considered?
Yes, sir. Let them consider my petition.
Page 40. we filed the stating that the case has been referred to the Court of the Law and Civil Judge, Senior Division, on Section 64.
No, the stand is their case is that they have not yet
Utilized
received
the-
any compensation. Number one. Number two is that land has not been utilized for which it was acquired. That is also there in that representation. So they are claiming that it in view of section 101.
We take instruction on that respect, my lord, whether they are receiving the compensation or not.
You
or-
see, why we are directing if you consider the representation and you say either that you have received the compensation matter board,
If you
or
don't require it, give it back.
if it has already been acquired, it has been already used, also you reject the representation.
Yes, Lord.
And if no compensation has been paid and it has not been used and not likely to be used, then
Yes,
the
that-
provision
yeah.
under section 101, you return it. So why you take instruction, the authority has been let you know. This writ petition has been filed by so and so for a direction to the opposite parties for returning the lands of the petitioners acquired for expansion of road leading from Naka Gate to Chamdaka. As per the notification dated 1/11/2012, the Land and Council for the petitioner submitted that petitioner number 4, Srimati Binata Rasinanda, earlier approached this court in WPC number 20133 of 2017. With a prayer for a direction to the opposite party number 4, Special Secretary to Government of Odisha, General Administration Department, to allot a suitable plot in the adjoining area so that she could carry out her livelihood. And also rejecting her representation for such purpose. Land Council submits that by order dated 26/11/2019, this court remitted the matter back to opposite party number 1 and opposite party number 4 to consider the grievance of the petitioner in accordance with the provision of the right to so and so 2013 Act. And also to consider the applicability of the Rehabilitation and Resettlement Scheme 2006 to the land acquisition notification. Stop. It is the specific case of the petitioner that even though in meantime more than 5 years have elapsed, government has not commenced any work over the acquired land, and the petitioners are residing over the land peacefully. it is the further case of the petitioners that they have not received any compensation for the acquisition of the land. Land Council submits that in view of the provision under Section 101 of 2013 Act, the unutilized land is to be returned to the person concerned if it remains unutilized for a period of 5 years from the date of taking over the possession. And to the original owners or their legal heirs. Stop. It is argued that a representation has been submitted before the so and so, that is opposite party number one
with copy to opposite party number 2 and
with copy to opposite opposite party number 2 with a prayer for
2 and 4.
1 and 4.
2 and 4.
2 and 4. To consider the case of the petitioner sympathetically and to return the unutilized acquired land for which they have not received any compensation. However, in spite of receipt of such representation, the petitioners have not received any response from the opposite parties. Therefore, necessary direction may be issued to the opposite parties. Number one, to consider the representation of the petitioners under Annexure 2 in accordance with law and communicate the decision within a stipulated time. Land Council for the state has no serious objection to such submission. Considering the submission made by the Land Council for the respective parties, without entering into the merits of the case, in view of the limited nature of grievance, we direct the opposite party number one to consider the representation filed under Annexure 2 in accordance with law within a period of 3 months from the date of production of the certified copy of this order, and communicate the decision to the petitioners within a period of 2 weeks from taking the decision. Needless to say that if for consideration of the representation, there would be necessity of giving personal hearing to any of the petitioner, the same may also be taken recourse to. Accordingly, the petition is disposed of.
Item 15.
May I please? Connected 5 these petitions were filed. In 4 cases, your lordship passed an order to supply the land particulars. This is one of the order, and the matter will be placed after the ensuing summer vacation. Here the land question is under Article 338.
Similar matters have been pending.
Yes, your lordship passed an order to put up after vacation.
Just
These 4 numbers I am giving. All the matters may be taken up together.
14 to 18.
No.
Today?
No. The others are other matter. Item number 15 is.
There's acquired since 1954. That is the steel, Raultra steel plant.
तो जोड़ा को करेक्शन हुआ था कर दी जाए
हाँ कर दी सर
जैसे ऊपर का पिटिशन और नाटा करेक्शन करना है तो ऊपर का पिटिशन और ना करेक्शन करी रिट पिटिशन रो नंबर का भी करेक्शन होगा है ना ताकू देखी लखी देवे और
जॉनसन जो
सामने में चेक कर सामने में तो सब बाकी सब ये नोटिफिकेशन से थिला अनेक्चर टू सब सेम देखिए करिए कुछ करेक्शन करछन दिया और कुछ करना अच्छा दिस इज टू कम अलोंग विथ ये गुडा राइट है ना 16 same?
No, madam.
Item 16.
Here, the petitioners claim the employment because of their acquisition of their land.
Of the railway have been challenged.
Mm-hmm.
The order of the railway
under Annexure 9.
Under Annexure 9. Southeastern Railway, Chakradarpur Division.
Union of India.
I request to my senior to copy.
Copy देना थी.
This copy दीजिए.
ना.
अच्छी नोटी documentary.
हम दे स्टेट को दीजिए. Perhaps
ଗୋଟେ କପି ଦିଅନ୍ତୁ ଆପଣଙ୍କର ମେନ୍ ଗ୍ରିଭାନ୍ସ ହଉଛି
sorry
railways.
I'm sorry. Full short कर.
Yes.
ना ये लिखित डेजिग्नेशन था.
Tinda 16, 17 and 18.
अच्छा. Your main grievance is against
railways,
no?
Railway only. Now.
Since this writ petition has been filed with following prayer for them, the Swansu submits that is appearing for the Union of India. That is opposite party number 1, 2, 3 for them. Submits that the copy of the writ petition has not been served on him. Mr. Samuel and counsel appearing for the petition submits that he will serve the copy of the writ petition on the Land Council for the Union of India by tomorrow or the other time.
No.
By tomorrow. Is this matter next week? Okay. The same order which he would have made. 16, 17, 18 times. Next week for the date दे देंगे 5 तारीख ऐसे हो 05/05/2025.
Item 19.
Item 19, may please your lordship.
Yeah.
Lords, here I'm challenging the order of the Learned Claims Commission, by which the Learned Commission has rejected my prayer for structured compensation. This is pursuant to the directions of the Honorable Apex Court, by which the Honorable Apex Court has directed your lordships to hear this matter. Your lordship has passed similar orders just on 16th. So I'm giving a copy.
The correction for the
it is same order, your lordship.
Correction particular.
Correction, sir. What I will do, 4 matters are there. I will just make memo.
No,
your lordship, only your lordship has quoted the prayer in the writ application.
I say prayer you khata number
my lord, sir, the prayer is there in my writ application. A detailed prayer is there in the prayer portion of my writ application.
The prayer portion ta change hobo.
Again, everything else is same. The opposite parties are same.
Parties same.
Opposite parties are all same.
Yeah, a prayer portion ta change kar debe. If khata number, plot number all that. Writ petition number change hobo, party na petition number change hobo. Party paragraph 4 ta same rahibo. 5 ta bhi same rahibo. 6, 7, 6 it you 21/4/2025 ଅଛି paragraph 7 ସେଟା ଆଉ ଗୋଟେ ଡେଟ୍ ଦେଇଦେବେ है ना
When these matters are coming up for hearing?
5th May
Your Lordship,
2025.
that matter is fixed for 5th May. But
We come in 6th.
but 5th May will be very less, maybe 1 month after.
So requisites এটা দিব ছুটি করব দিব এটা নোটিশ অফ অপোজিট পার্টি নাম্বার 2 মহানদী কোলফিল্ড ওরা ছুটি করে দেবো
And it's item number 20, 22, 20.
Just a minute. এটা ইস্যু নোটিশ করলাম বাকি অর্ডার করলাম 20 then
Your Lordship, 19, 20, 22, 23. Format is same.
23, 24.
Up to 23.
Yes, my lords. My lords, except 21.
That's even lot number that's the number.
Except 21.
हाँ 20 21টা নয় তো 21টা अलग নাম ঠিক আছে দেখো
Grateful, my lords.
Item 21.
May I do? Challenging the action of the opposite party to non-payment of compensation, though the compensation has been assessed, running page 38 euros, 32. Compensation amount has been assessed, thereafter running page 31, submitted before the government.
ଏରା ସାଙ୍କସନ ପାଇଁ ଥିଲା ନା ଆଉ ଗୋଟେ ଅର୍ଡର ପାସ୍ ହେଇଥିଲା ଆଉ ଗୋଟେ କହୁଛି
Similar order I have annexed to your lordship.
କେତେ ନମ୍ବର
Running with 33 my lord. Sanction is ନାଇଁ ଏଟା
ନାଇଁ ଆପଣ ଆଉ ଗୋଟେ କେସରେ ଆଣିନଥିଲେ ଯେ ସାଙ୍କସନ ହେଇଗଲାଣି ବେଟି
contempt application.
କଣ୍ଟେଣ୍ଟ ଅଛି ଏଟା 27/12/2024 ରେ ଆଡ୍ରେସ ହେଇଛି
Committed
foreign order be revised also submitted with the requested that the digital amount may please be sanctioned to expedite the payment. I think instruction ନିଅନ୍ତୁ କାହିଁ ତାକୁ ଇଏ କରିବେ ସାଙ୍କସନ ହେଲେ ପୁଣି ତାକୁ ଡିସ୍ପୋଜ ଅଫ୍ କରିଦଉଥାଉ ସେ ପୁଣି ଆସିବେ ତାପରେ କଣ୍ଟେମ୍ପ୍ଟ ଫାଇଲ ହବ ଏତେ ଜିନିଷ ନାହିଁ ତ ଡାଇରେକ୍ସନ ହେଇଛି ସାଙ୍କସନ କରିଦେଲେ ସେ ପେମେଣ୍ଟ ହେଇଯିବ ଲେଖନ୍ତୁ this petition has been filed by the petitioner Kobi Bala Ketoki. It's a prayer for a direction to the opposite parties number 2 and 3 to release the compensation amount of ₹1, so prayer portion of the queue on acquisition of land advances of the queue. The land council for the petitioner placed the calculation sheet of the decretal dues in the land acquisition case under section 18(1) of the Land Acquisition Act, which has been done by the special LA and ROR Lower Indra Irrigation area opposite party number 3 and is later addressed to Director R&R from Additional Secretary to Government Department of Water Resources Swansea under Annexure 4 from opposite party number 2 for sanction of the decretal award amount to expedite payment to the decree holder. The Land Council for the petitioner submits that even though such letter has been issued on 27/12/2024, but no such sanction has yet been received as per his instruction, for which the petitioners are deprived of getting their legitimate benefits as calculated by the opposite party number 3. Let the land council for the state obtain instruction on the status of annexure court regarding sanction of the decretal award amount out of this matter. छुट्टी पड़ू जाओ नहीं जाओ yes after vacation summer vacation.
Item 24.
I am for opposite party my lord. I am preparing the counter my lord. Yeah, four
Which for the petitioner?
Yes, madam. Four miscases they have served in previous week. So I may take some instruction in this miscase my lord. They have served.
No, counter file करी ना.
नहीं, मैं prepare कर देची कर दे भी.
बाकी ये जो आई कॉपी वाला
दिले कोला वीक रे दिले से मते.
You want to obtain instruction on
instruction रे हेले मु देबी.
Alright,
after vacation हेले मु सब उड़ा दे देबी एकाथरे सुनानी हे जो
council for the you are appearing for which opposite party?
Opposite 9
ठीक से देखिए सर.
हाँ मैं को फाइल कर दी छे. Opposite party 9 लड़ा. 9, 10 and 13 to 19.
The Mr. Swain, land council appearing for the opposite parties number 9.
9 and 10. 10 टा से substitution करछन कोन
हमको एते कथा कोंदनी कहा पई आपण appear करछन
मो 9 ଆଉ 13 to 19.
9 and 13 to 19.
19
submits that the counter affidavit is almost ready.
Madam.
And it will be filed within a week or more time.
More time is required, madam.
It will be filed before summer vacation, right?
Before summer vacation.
Before summer vacation, serving a copy on the land council for the petitioner. He further submits that he has received the copies of the interim application last week. And he wants to obtain instruction on such interim application. And the matter may be taken off after ensuing summer vacation. Release this matter. Date would there.
Obliged.
Item 25.
25 before I take my notes to the merits in one here. Principal, she ordered it 26th of November 2024, order number 1.
Petition of the Supreme Court, graduate. Petitioner has filed the
State view lordship, it comes to the last part of your counter affidavit, it can be filed in the meantime. Last part of that. No, they have not filed it. Central government.
Mr. Council for the Central Government, Union of India, who is appearing. Deputy Solicitor General is present. Council of the Central Government or no? On the item. So, as per order dated 26/11/2024, the opposite parties number 1 and 3, 1 to 3 were directed to file counter affidavit if any. Mr. Rothland, senior advocate, submits that he has not received any counter affidavit and he does not know whether the counter affidavit has been filed or not. None appears. Mr. Asiol, आपण counter affidavit file करलेनी ना करिया पई समय दरकार ना कोन?
Mr. Padi.
Mr. Padi.
Yes, yes. Yes,
this is item number 28 we are taking off. 25. Sorry, 25. And
Yes,
this a counter affidavit you took time on the first order. So is it ready or you want more time or what?
I need more time, my lord. Another council was interested. So I'll some time maybe give.
All right, stop. Mr. Pari, Learning Deputy Solicitor General, submits that some more time may be granted for filing the counter affidavit. List this matter. Some more petition for the
Item 26.
Just this one. There is a similarly placed matter that also should come with this.
अच्छी आज का list है.
List 9.
अच्छा, Mr. Author submits that these are the matters which are connected. Please give the list.
Just.
And it may be listed along with so and so. List this matter along with so and
That
so.
in one go matter. Great.
Next.
Item 26.
My lord, on behalf of Madam Jirna, the last date that is 18/3/25, state has to file the counter.
Yes. Counter has not been filed, but here the order has been challenged.
Last time request was made to file counter.
You have stated that you have received the para-wise comments and you will file the counter affidavit within 3 weeks. That order was passed on 18/3/25.
Yes, sir.
3 weeks is already over, and that is how we have called this matter to today. Now,
another one.
In this matter, the Learning Council for the state submits that some more time may be granted to file the counter affidavit. List this matter after summer vacation.
Lord, in this case, I am appearing for OP number 4. I may be granted 4 weeks time to file counter.
Just a minute. Opposite party number 4 here.
Chief General Manager Rumta.
Mr. Rasmi Ranjan Swain.
Yes, my lord.
Land Council appearing for opposite party number 4 shall also submit that he will also file the counter affidavit in the meantime. ये पर file कर दे. Yes.
Item 24 interim order may be continued. Item 24.
Interim order thila.
Aye.
24 रे interim order अपन नहीं करे dictation देखी देवे जदि interim order थिला तले continue करियो है ना verify करो. Yes, next.
Item 27.
I have filed an application for amendment because of the subsequent development which came to the knowledge of the petitioner.
नहीं counter affidavit rejoinder सब गुड़ा का फाइल ही गला.
Sir.
तारपरे पुनी कौन गुटे पुनी आसिला पुनी.
You counter rejoinder, everything is filed. What has happened in the present case?
Where is the interim application for amendment?
Yes, if you are so kind to see that I is there.
What is that amendment? What is the schedule of amendment? Have you given a copy to the other?
Yes, I have given an objection has also been filed.
Sure.
But IA 3291 of 2025.
No, this was filed on 21 through 2025.
Yes, Maharaj.
So, any order was passed on that IA?
No order has been passed.
So, Mr.
They have served us a copy. We have filed an objection and we are strongly objecting.
You are appearing.
I am instructed to appear for the OP number 7.
अच्छा, OP number 7, Mr. Roth. अच्छा, बाकी it is noting that Mr. Tarun Patnaik is appearing for opposite party number 3. So, any objection has been filed or
no objection has been filed except OP number 7.
We have filed our objection. But if anyone else would like to file objection, that's a different matter.
State has no objection. Just let us see who are the parties so that we can pass an order.
State is opposite party number 1.
Just
Number 2 is tourism department.
so that is also you. 2, 3 is also you. 4 is also you. 5 is also you. 6 is also you.
6 is also.
7 you are appearing.
3 is not there. 3 also OTDC, Development Corporation.
अच्छा OTDC ପାଇଁ ତ
Mr. Patnaik.
ତରୁଣ ପଟ୍ଟନାୟକ ନାହାନ୍ତି ଆଚ୍ଛା ବାକି ହେଲା 7 ତ ଆପଣ ଅଛନ୍ତି so any serious objection or will allow Mr. Roth
Big pardon.
any serious objection to this?
I have a serious objection. It has to be heard.
So Mr. Mishra, please place it.
Well, if your lordship can have a look at this amendment which I am seeking for.
Yeah.
I'm trying to incorporate.
Just a minute. The objection which you have filed,
Right, my lord.
when you filed the objection, because that is on
Objection.
not on record. Have you received the copy of the objection?
Yes, yes, we saw the copy and we have filed it, but maybe it might have been scanned. Least
Scan to him.
When have you filed?
Yesterday. Yesterday.
Yesterday also. So let it come next week with the objection.
Let's fix a date.
We'll fix it.
That's right.
Acha, IN number 3291 of 2025. This is an application for amendment of the writ petition. Mr. Rothland, senior advocate, appearing for opposite party number 7, submits that yesterday he has already filed objection to the interim application. The objection be placed on record of this matter on Quebec 6 supplementary near
Let it be 6th or 7th.
6th or 7th. Mr. Mishra?
6th.
6th or 7th.
6th May 2025.
Great.
The rest of the matter tomorrow.
Our actual 20, can I make a mention on?
20?
28, next time. This has come for the first time after my appearance.
I'm sorry, sir, the interim order is there.
Interim order, continue.
28, I need to file counter for OP1.
Who is for the petitioner? Mr. Pandey. No, he wants time to file the counter affidavit. Have you any objection?
No.
Mr. Kanungo, Land Council, appearing for the opposite party number 1. Opposite party number 1 seeks some time to file the counter affidavit. Please, this matter after summer vacation. Counter affidavit, if any, be filed in the meantime, serving a copy on the Land Council for the.
Next matter, item number 29. This connected matter, the opposite party, they have filed. That is 6048 of 28. I have filed their petition, also filed vacation of state. That is not listed in spite of my memo. So this may be 6048 of 25.
That matter is to come along with this.
Along with this.
So tomorrow it will come. What is it?
Yes.
In fact,
you
have seen this, the present writ petition which is listed. I have sought the parawise comments, it has come. I'll file a counter affidavit within a week's time.
Okay, you are appealing for which opposite
together
party?
with the other writ petition in the next week.
No, which opposite party you are?
And for 2, 3 and 4.
Achha, you have not filed the counter affidavit.
No, so I'll file, I've got the parawise comment.
All right,
from
Mr.
the
Acharya, Land Council, at item number 29, appearing for opposite parties number 2, 3 and 4, submits that he has received the parawise comments and will file the counter affidavit by next week, serving a copy on the Land Council for the petitioner. And stop. The Land Council for the petitioner submits that this matter is connected to
6048.
Please give it a number. One writ petition or other
one writ petition.
Is connected to WPC number so and so, and the same may be listed
Together next week.
Put up this matter on such and such date.
Stay is operating in that case, second case. So that is why I want my prayer praying that it should be listed for all.
Direction hela asibo ta singe ra kon number ta diary ta dekhi ke date ta karibe ko date ra asibo hela so yes baki ni asibo karibe 27
Yes. On behalf of Ambika Prasad Rai, item number 17, prayer for adjournment.
Let us see, wait, go serial, yes.
Supplemental list, item number 1.
Comment or vote? Comment or vote on perform. Peacefully, no. I could circle with you. Again, final as it List of the has sent a petition that in place of Mr. Rajiv Lochan Pradhan, one government advocate may be, but government advocate cannot be for an appellant. So we are engaging you as amicus curiae. Grateful is not. Here is the prisoner's petition at flag J for engagement of an advocate in place of Mr. Rajiv Lochan Pradhan. Mr. So-and-so is engaged as the amicus curiae for the appellants. Intimation be given to the appellant in that respect. By the registry body. Yes, next.
Item 2.
Obtain the instruction that
You answer a special campaign on the 70 ବର୍ଷ.
two cases pending the jurisdiction. One is the case number 21/98. Is the criminal appeal number 192/2001. That is still pending, but in the meantime, on 21/2012,
Yes.
Thereafter, another case. For there out the case for that present
Just a minute. This criminal appeal. The GR case number 770. Acha. Convicted and he has been serving Senegal. He has preferred the appeal. Okay. Custody since 11 years, 9 months. Acha. Attained the age of 70 years. As per the available occurrence, so and so was admitted to this jail in connection with another GR case. Oh, that was also under section 302.
That is also 302.
Convicted for life. Released. Oh, it's a premature release.
The premature release.
On express. So, now, in this case, he has remained in custody for 11 years, 9 months. Look,
this is also 302. Earlier,
a prisoner's petition has been received. What is that prisoner's petition? at flag, no, no, at flag B for release of the appellant flag B for his release in view of the NALSA special campaign on old prisoners and terminally ill prisoners. Stop. It is mentioned in the form that the petitioner is aged about 71 years. We asked the Land Council for the state to obtain instruction on the application, and today the Land Council for the state has produced the letter dated 22/3/2025 of the Senior Superintendent Sarkarjee Hon'Ble, wherein it is mentioned that in connection with this case, the appellant has spent 11 years, 9 months in jail custody, and he has attained the age of 70, more than 70 years. However, it is mentioned that the petitioner was also found guilty in another case, that is which arises out of GR case number 318 of 1997. In
we are 307.
Who does?
318 minutes.
See, our case time.
And case number 21.
318 of 1997, in which he was found guilty under section 302/34 of the IPC, and which corresponds to ST case number 21A of 1998, bracket 39 of 1998. In which he was found guilty under section so and so and sentenced to RI for life by the learned additional session judge Ankur, and he preferred criminal appeal number 192 of 2001 before this court. However, in the said case, he has been released prematurely on 28/1/2012, unexpired portion of his sentence having been remitted by government by Law Department letter number 1063 dated 18/1/2012. The relevant document has also been annexed to the letter of the senior superintendent, which is taken on record. Considering the period of detention of the petitioner in jail custody and his age and absence of any chance of early hearing, we are inclined to release the appellant on bail. Hello? So he shall not indulge in any criminal activity. 20,000 one surety for the next.
And that's CRA 192/2021 is still pending.
Good.
So you premature bail judgment.
So it is premature release है डिस record CRA ना कौन?
CRA.
CRA.
That is not pending ଅଛି.
ताकू सेटा को लिस्ट कर ऐसे तो खाली लिस्ट कर दो.
192/2001. 192/2001 CRA.
Next.
So
Item 3.
May I please, sir? On behalf of Mr. Ramdas Acharya, may be permitted to
Last matter directed to obtain the custody certificate
and antecedents.
Dita ଜିନିଷ କହିଲା custody certificate plus antecedent. Custody certificate କେତେ ଦେଖଉଛି?
13 years.
13 years. अच्छा, आओ बाकी
13 years, 10 months, 1 month.
आओ
Antecedent?
any
Antecedent valid report not received.
offense no.
Lord, initially I was charged for offense 498A 302 304 E of IPC and section 4 of DPI.
Yeah.
But subsequently I was convicted under 302 of IPC.
You are acquitted of the other charges.
Yes.
My lord, dying declaration is there recorded by the executive magistrate, Dr. P.W. 13. He given
And whether the bail application has been rejected on merit earlier.
No, my lord, it was admitted on.
Bail application was not moved.
So 13 years well now. What is your good name?
Park Agrawal.
Nathan. And Mr. Swain. On behalf of Mr. Ramdas Achay, as per the order dated 11/4/2025, the Learning Council for the state has produced the written instruction received as a pursuit received from the Senior Superintendent Circle Jail, Barampur, dated 21/4/2025, which indicates that the appellant is in judicial custody for more than 13 years.
13 years, 10 months.
13 years, 10 months. The custody certificate is taken on record. The Land Council for the state hours submit that he has not received the instruction relating to the criminal antecedent. Considering the period of detention of the petitioner in judicial custody and absence of any chance of early hearing, and the nature of evidence, the first nature of evidence, we are inclined to release the petitioner appellant on bail. Yes, next.
Item 4.
Mr. Ponda. Now the next.
Item 5.
Nalsara.
Last order is 17.
এটা কো ক্যাটাগরি আসি 70 ବର୍ଷ ହେବ ନା କଣ
81 years old.
81.
ଆଚ୍ଛା ଆଚ୍ଛା
2020 ରେ 75 ଥିଲା.
The life on 81 is suffering from so and so affected are the Land Council for the petitioner Land Council for the state in pursuance of the order dated 17/4/2025. The Learning Council for the state has produced the written instruction received from Superintendent Special Subjail Devgad dated 26/4/2025, wherein it is mentioned that the petitioner is aged about 81 years and he is suffering from coronary artery disease, bracketed CAD with STN, and affected mature senile cataract, and he is unable to perform his day-to-day work due to the old age and blindness, and he has lost his potential to commit any further crime, and he requires special needs to take care of his daily routine. The written instruction is taken on record. Considering the age of the petitioner, his health condition and period of detention in judicial custody, as well as absence of any chance of early hearing of the appeal in the near future, as paperwork has not been prepared, we are inclined to release the petitioner on bail, stay realization of fine. Yes.
Item 6.
Yes. Asila.
Yes, hello.
ବୟସଟା ଆଣିଲେନି ବୟସଟା ଲେଖିଲି
କିନ୍ତୁ ଏଥିରେ ଜଜମେଣ୍ଟରେ ଅଛି।
ହଁ
71 ଥିଲା 2020 ରେ।
ଏଠି ଲେଖିଛନ୍ତି 74 ଲେଖା ହେଇଛି।
ଭଲ ଠିକ ଅଛି।
All right, heard the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the
ବହୁତ କମ ଦିନ ରହିଛି।
ସେମିତି କମ ଦିନ ଫିନ ସାଙ୍ଗରେ କିଛି ତ ନାହିଁ ସେମିତି ନା ଏଜ୍ ଆଉ ଟର୍ମିନାଲ ଇଲନେସ୍ ଉପରେ ଦେବାକୁ କୁହାଯାଇଛି as produce as per the order dated as produce the written instruction received from Superintendent Special Subjail Talcher dated 26/4/2025, wherein it is mentioned that owing to the old age, the petitioner is expected to lose his potential for committing any further crime. The petitioner has been shown to be aged about 74 years in the format of the National Special Campaign on Old Prisoners and Terminally Ill Prisoners. Considering the age of the petitioner and it is 302 case.
302. Eyewitness at
and the nature of evidence available on record. After hearing the land counsel for the parties, we are inclined to release the petitioner on bail, stay realization of fine.
କମ ଦିନ ଯାଇଛି ନା ନାଚ ବାଲା ଲେଖିଦେବି।
এটা নালসা গাইডলাইন লিখলে yes
এটা কম দিন ଯାଇଛି না সবাই নাচা
Nalsa guidelines लिख दो है ना form has also been filed by no
written.
Item 7.
Yes, 7.
Yes, once. Report.
এটা কোন সেই নালসার
Your Lordship was 85.
85.
नहीं ये नहीं करो जो
Your Lordship on 9/4/2025.
9/4/25
अच्छा
अच्छा
2023 ରେ 80 years ଥିଲା।
এটা जो আসেনি এটা আসেনি না
Which report which? Superintendent jail partition.
85 years.
Lucky them. IN number 205 of 2025. This is an application for bail as per the order dated 22/4/2025. The Land Council for the state has produced the written instruction received from IAC Dunguripalli Police Station, wherein it is mentioned that the petitioner is now aged about 85 years and so the report is taken on record. आपको रिजेक्ट ही चाहिए
No.
Hmm. 302 case.
Eyewitness was there. PW4.
What is your period of detention?
Under since it was 17/8/2019.
Actually,
5 years, 7 months.
here is the imposed judgment after hearing the land counsel for the respective parties in view of the nature of evidence available on record, the period of detention in judicial custody, absence of any chance of early hearing of the appeal in the near future since paper book has not been prepared. And moreover, the days of the petition. Paper book moreover, the absence of counsel, early hearing, chance of early hearing, and more particularly the age of the petition. We are inclined to release the petitioner on bail, sterilization of time. Yes, next.
Item 8.
May I please, Your Lordship,
Keeping in
offense
view the
under
NALSA guideline.
302 IPC.
NALSA guideline regarding to the old age prisoners and terminal illness. So wording used for it. Yes, item number 8.
May I please, Your Lordship, offense under 302 IPC. My Lord, custody since 17/2016. My Lord, allegation due to quarrel between deceased.
Wait, just a minute. So you have got the deposition copies. So 302 case, and you are in custody since 17/11/2016. 17/11/2016. Page number 3, column number 1. When we have 8 years. Okay. So deceased Uchi Ranjan Pradhan. Date of occurrence 15/11/2016, 7 p.m. Sure. Asked for ₹80. Who is the accused took going down? Informant came on notice that an arrow has been pierced in the chest, standing holding a book. So, shot an arrow. Eyewitnesses are there? No.
Subsequently, just
He was found present at the
with a bow.
With a bow.
Arrow was pierced with the deceased, and this person was found holding a bow just after the incident.
Who are the witnesses stated about his presence at this spot?
It's a confessional statement for the PW6 and mother had seen the PW1.
PW1 and PW6.
PW6. Before whom he has confessed that, I have to say.
And also confession is there?
Yes.
Before whom confession is?
PW6 man.
PW6 confession. Confession as well as his presence at this spot.
Yes.
PW6 evidence bar.
PW1
PW1 also. He was citing Mote Rakhyakara, Ponchu, Bindhi Dela. Accused rushed to us and told that he committed a blunder and had killed the deceased by wound. And what about the doctor? Who is the doctor? PM.
Doctor is PW2 man.
PM doctor.
Yes, ma'am.
What he has noticed? Piercing or stabbing type of incident. Acha. Penetrating type of incised wounds also. and RO was sent to her by the for query, examined the weapon of offense. The RO was brought in, the opinion and the injuries found on the body was exactly consistent with the weapon of offense, and all the injuries are possible by small. RO पढ़ाई की रखा है क्या तापर पढ़ाया अच्छा. Yes, Mr. Tripathi.
Madam.
What are the, how many cases you have got? How case achi?
No criminal action, madam.
No criminal is done. What is your local? On go.
On go job pada madam. Okay.
ସେଦିନ ମୁଁ ଇଟା ଭାଟିରେ ଥିଲି, ମୁଁ ତୀର କିମ୍ବା ଧନୁ ଧରେ ନାହିଁ, ମୁଁ ଜାଣିନି କିପରି ରାଜନ ମୋହନ ଅଛନ୍ତି. ଗୋଟେ ଇଏ ହେଇଥିଲା, କଳି ହେଇଥିଲା ଯାହା ଜଣା ପଡୁଛି, ୱାର୍ଲଡ ଇନସୁଲ ହେଲା, ତାପରେ ସିଙ୍ଗଲ ସଟ୍ ମାରିଛି.
80 ଟଙ୍କା ନେଇଥିଲା ତ ପଇସା ମାଗିଲାଠୁ
ମନିଟାରୀ ଇଏ ନେଇଥିଲା, ଡିସିଜ୍ ନେଇଥିଲା 80 ଟଙ୍କା ନେଇଥିଲା, ଫେରେଇଲାନି ଆକ୍ୟୁଜ.
ଇଏ ନେଇଥିଲା 80 ଟଙ୍କା.
ଇଏ ନେଇଥିଲା, ଆକ୍ୟୁଜ ପଞ୍ଚୁ. ଆଚ୍ଛା ଠିକ ନୁହେଁ, ପଞ୍ଚୁ ନେଇଥିଲା, ଡିସିଜ୍ ତାକୁ ମାଗିଲା, ଫେରିଲାନି, ସେଥିପାଇଁ କଳି ହେଲା, ଇଏ ତ ବିନ୍ଧି ଦେଲା ଆଉ କଣ. Are the Land Council for the petitioner, Land Council for the state. The Land Council for the petitioner submits that the petitioner is in judicial custody since 11/2016 and also she has remained in custody for more than 8 years and 5 months. The occurrence in question took place on 15/11/2016 and there are no eyewitnesses to the occurrence. However, the post-occurrence witness like PW1 and PW6 have stated that the accused was present at the spot holding a bow and the deceased was lying being shot with an arrow. And the Land Council submits that the evidence on record indicates that there was quarrel prior to the assault, and in view of the background of the case and surrounding circumstances, the ingredients of the offense under section 302 IPC are not attracted, and there is no chance of early hearing of the appeal in the near future. Balance of convenience is in favor of the petitioner and therefore the bail application may be favorably considered. The Land Council for the state, on the other hand, oppose the prayer for bail, place the evidence of PW1 and PW6 and submitted that PW6 has also stated about the extrajudicial confession made by the petitioner, and the doctor bracketary PW2 who has conducted the post-mortem examination has opined that the cause of death was due to penetrating type of incised wound with the vital organs like heart and lungs and liver, diaphragm and descending aorta shock due to severe bleeding. It is paragraph 2 of the evidence of the doctor. And further, on examination of the RO, which was blood cleansed, who find that the injury present on the body was exactly consistent with the weapon of offense, and the injuries are possible by such weapon. Considering the submission made by the Land Council for the respective parties, the nature of evidence adduced, the surrounding circumstances under which the offense alleged to have taken place, stated to have taken place for them, the period of detention of the petitioner in judicial custody and absence of any chance of early hearing, we are inclined to release the petitioner on bail allowed and stay On a head, head injury.
There is no head injury.
Therefore,
17 you can see.
They were in the regular course.
But back purpose, I see.
Chest, shoulders also.
Chest
Both
injury.
of the abdomen to chest. Hip rupture. Right side will go to arms rupture. Both of the rupture. Base of the neck.
Or the land counsel for the petitioner and counsel for the state. The land counsel for the petitioner submit that the petitioner is in judicial custody since 30/10/2020. And though the eyewitness PW3 has stated that the appellant assaulted during quarrel between the appellant and the deceased, the appellant picked up a bamboo stick and assaulted the deceased on the head by such stick, but the doctor, bracket PW17, who conducted post-mortem examination, has not noticed a single injury on the head, rather noticed injuries on the other parts of the body, and opined that the cause of death of the deceased was due to injury to the lungs, liver, causing bleeding, leading to hemorrhagic shock, and further opined that the death of the deceased may be homicidal or accidental. It is argued that in view of such medical evidence, the evidence of the eyewitness is very difficult to be accepted, and there is no chance of early hearing of the appeal in the near future. Balance of convenience is in his favor, and therefore the bail application may be favorably considered. Land counsel for the state oppose the prayer for bail and praise the evidence of the eyewitness PW3, so also the evidence of the doctor PW17. Considering the submission made by the land counsel for the respective parties, nature of evidence adduced by the prosecution during trial, the period of detention of the petitioner in judicial custody and absence of any chance of early hearing, we are inclined to release the petitioner on bail, sterilization of time.
Item,
next.
item 10.
Copy of the deposition in item number 6. The land counsel for the appellant shall supply the copy of the deposition to the land counsel for the state. Put of this matter will be commencing from 12th of May 2025. Yes.
In both the matters.
Both matter?
Both same.
10 out sub item.
Deposition to go 10 number na? List this matter along with CRLA number 93 of 2025. Yes, next.
Item 11.
Item 11 matters. Just now I am serving the deposition copy to
The land counsel for the appellant saw the deposition copies of the witnesses on the land counsel for the state who seek some time to go through the same. Put of this matter, 12/5/2025. Yes.
Item 12.
Case admission matters. There is delay of 306 days, my lord.
Yes, sir. Delay of 306 days. You have filed a delay condonation application.
Yes, madam.
And bail of 760. And it is a life imprisonment.
Yes, madam.
IN number so and so is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 306 days in filing the criminal appeal. After hearing the land counsel for the respective parties, the grounds taken in the interim application, and since the petitioner has been sentenced to imprisonment for life, we are inclined to condone the delay in filing the appeal. According to delay is condoned IA is disposed of, but admit for the trial court.
There is a fourth appeal is there. Connected appeal. ILCR is there.
Stop, just a minute. Stop. At this stage, when counsel for the appellant submits that there are 4 connected criminal appeals and the trial court record have been called for, has been called for in those appeals, put up this matter along with CRL number so and so. The registry shall verify regarding availability of the trial court record in those case records. No? Yes, next.
And the counsel in that appeal also, the other appellants are already released on bail. I pray for next week, madam, so that it can be hard.
All right. You supply the deposition copy.
Already supplied. They are available in the said appeal. I am the counsel in that appeal also, and they are also released on bail, madam.
Okay. Next.
Item 13.
I pray next week, madam.
Yes.
Yes, obliged.
Depositions totally supplied, madam.
Ajidale.
No, I would.
Yes, Mr. Mahdi. Okay.
Yes.
You have received the deposition copy. Yes.
Conviction under section 302. Around 26 witnesses have been examined. None of the witnesses supported to the case of prosecution. Trial court convicted that on the body of the deceased there are injuries. No one has stated that I am the author of the crime. The PW11 is the wife of the deceased, madam.
Just a minute. No, it is a trial court record. You mean to say that the witnesses all have sworn outside?
Yes,
sir.
All the witnesses are relatives of the accused and the deceased. Both are family members.
Just a minute. Shari. Ichi evidence achi?
PW9 ko chi.
9.
Yes. Informant is the PW11. And she is the wife of the deceased. PW9 ko chi, he heard a halla. May I read the relevant part? PW9.
Not about the hostile regime or the
Paragraph 2, the incident occurred 1 year, half months back. I heard holla of the informant that her husband was killed by the accused by means of a tower. I went near the deceased where the dead body was lying. There is no eyewitness. PW8 was the sister of the accused as well as the deceased. So she says
no. This is not a. You see, this is not the dying declaration.
This is not dying
declaration. He heard the halla of informant.
Informant.
Okay. Yes, informant has stated that I saw the accused assaulting and that is how I raised halla.
PW11 was the informant. She has said, I have not seen the occurrence at all.
How can he raise halla? That accused has assaulted.
In her 164 statement, she has said something, but she has resiled in the deposition.
No. If PW11 para kouchi, accused dead, tawablo.
Paragraph 4, member.
I have not
seen the occurrence. I read the place of occurrence after the occurrence was over. Yes, after 9 reports, I was not examined by the police in case. I do not know about the context.
Custody since?
On the initial date of arrest, that is date.
23 years. The occurrences of 23. There are
14
injuries.
2 years. 2 years.
There are 14 injuries and section 27 recovery is there.
14 injuries.
14 injuries.
Who is the doctor?
PW24.
24.
But 27 of the tower recovery is that witnesses are PW3 and 5. They found outside.
Tawa is the weapon of assault according to the prosecution. How you are related to the deceased?
Separate from police.
Nijo bhai.
PW8 होची भौन से कुछ आगुरु डिसीज समस्त गाली मंद करथला मद पीके सेथि पाई के एंगेज तो काइंडली सी PW24
24 yes
injury
that is the deposition of the doctor
multiple injury
14 injuries.
No, it's all right, but let us say he has sustained 14 injuries, which is definitely a serious thing, and cause of death was also due to, but unless you prove that the accused is the author, of those injuries, how can we establish the guilt? And except that somebody, that informant was shouting, what else is there? Because no, and that tawa was seized. Any bloodstain was found in that tawa.
No.
Whether that it has been sent for chemical examination.
No.
I'll just check.
Come to the judgment last phase. See the exhibit list.
Yes.
Whether any C report is there or not.
MO5, huh? Tawa MO5.
MO5 is here.
Nice C report. C report kind spot map, command certificate.
Moment.
Where from this tawa was seized?
In the house of the
House of,
appellant.
from the veranda of the house of the.
At your instance.
Yes.
At his instance.
The witnesses are PW
PW?
4, P and 5.
P and 5, huh?
20th is also there.
They have also not supported the prosecution.
Some of
the family members, they have tried to save the appellant.
Are the land counsel for the petitioner and counsel for the state? The land counsel for the petitioner submit that the petitioner is in judicial custody for more than 2 years. And not a single witness has stated that the petitioner has assaulted the deceased. And they have supported, they have turned hostile. The land counsel submits that in view of the available material on record, there is every chance of success in the appeal and balance of convenience is in his favor. Therefore, the bail application may be favorably considered. Land counsel for the state oppose the prayer for bail and place the evidence of PW 24, the doctor who conducted post-mortem examination and noticed as many as 14 injuries on different parts of the body and opined that the cause of death was due to coma due to multiple injuries on skull and intracranial hemorrhage caused by the weapon. The land counsel for the state further submits that at the instance of the petitioner, one tawa was seized and the said tawa was produced before the doctor. The said tawa bracket like the MO5 was produced before the doctor, and the doctor has stated that the injuries on the person of the deceased were possible by such tawas. He submits that the petitioner is the brother of the deceased, and therefore he should not be released on bail. Land counsel for the petitioner submits that the witnesses to this seizure, that is PW3 and PW5, have not supported the recovery part. Considering the submission made by the land counsel for the respective parties, the nature of evidence adduced during the trial, since the witnesses have not supported the prosecution case regarding the petitioner to be the assailant of the deceased, and taking into account the fact that there is no chance of early hearing of the appeal in the near future, we are inclined to release the petitioner on bail, stay realization of fine.
Item 14.
260 days.
Kete dino?
262.
High Court delay condonation. IN number so and so, this is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 264 days in filing this criminal appeal. Considering the submission made by the land council for the respective parties, going through the amendments taken in the interim application, and since the appellant is sentenced to life imprisonment, we are inclined to condone the delay. Accordingly, delay is condoned, IA is disposed of, admit, call for the trial court reform. Put of this matter after summer vacation program. The position copies be supplied to the land council for the state in the meantime. Yes, next.
Item 15. May I just find out? The petitioner was charged entered the section 302 of IPC and imprisoned for life, and he is in the jail custody in the 10 years.
The position copy दे दी जल्दी.
Yes.
अच्छा.
Double murder eyewitness.
Oh, double murder. अच्छा. केबे ड्रॉ लेनी?
Actually, say 2016, 2000.
आइन जनी custody certificate आइन जनी. Custody certificate आसन आनु तो यो तारा criminal antecedent है ना? लिखों IA number so and so. This is an application for bail. Let the land council for the state produce the custody certificate. So also obtain instruction regarding the criminal antecedent, if any, against the appellant. Put of this matter after summer vacation. Yes.
Item 16.
Let the petitioner is on bail of his whereabouts is not known. His family members are they have no knowledge.
नहीं सुना नहीं परियो तो किसी ने submit that the petitioner was released on bail. What do you have report of the superintendent?
District judge क्यों sir?
क्यों जो हाँ dated होगी 28/4/2025. However,
second place.
The whereabouts of the petitioner is not known. The report is taken on that one. Let us सुना नहीं वो date fix up करियो है. Next.
Premature release on bail.
Kuda.
Next 17.
Beyond the report of the year the. Next.
Item 17.
He is available in the village. This item number 17.
17 premature release on bail.
No, 17.
Yes, 17 is premature release.
Premature release. Upon us. Who did? This is item number 17. The Land Council for the state has produced the written instruction received from the Senior Superintendent Circle Jail Baripata, which indicates that the appellant Gaurav Ganju has been released on 30/12/2022 from the Circle Jail Baripada on premature as per the Government of Odisha Law Department letter number so. The letter has been annexed. The written instruction is taken on record. Jail criminal appeal is accordingly disposed of. If the petitioner intends to file the challenge the conviction, he can file an interim application for recall of the order. Dispose of. Next.
Item 18.
Bail and act. Not that.
My question was whether the appellant released on premature bail as per direction of state government. No. Whether the appellant is alive or dead. If dead, please furnish the death certificate of the appellant.
कौन देले?
କିଛି ସେ ତାର ଆନ୍ସର ଦେଲେ।
अरे
Please.
और तो clarification मांगा।
My lord.
The learned counsel for the state submits that as per the order dated 16/4/2025, he has sought for some instruction from the superintendent sub-jail Rajgangpur, and he has received written instruction dated 23/4/2025, which indicates that though that the petitioner has not been released prematurely. However, it is not mentioned whether the appellant is alive or dead, and so also his period of detention in jail custody, and therefore he may be given some more time to obtain such instruction. Put of this matter, Bartari. Next.
Item 19.
Item 19. My lord, I may be pardoned for appearing on VC, my lord. And that report is a flag C.
Flag C.
Flag C. It is a report of 2023. At that particular time, the appellant was on bail and was staying in his native village. Flag C.
So this can be hard, there is no problem in that. Next matter.
Item 20.
ଆଉ ବାକି ଗୁଡା ତ ସବୁ ଅଛି
Item 20 ଗୋଟେ କଣ direction ଥିଲା appellant to obtain instruction.
କୋଉଟା?
Item 20 ରେ appellant to learned counsel for the appellant to obtain instruction.
So the counsel is not there. The land counsel is there or no? J.R. Das.
You can say last time it last to whether pursue the appeal as the appellants are not in touch with him for quite a long period.
No, is he coming or?
That was his submission last time.
No, J.R. Das was present on the last day. ଓ ଯୋଉଠୁ ଯୋଉଟା କି ହେଇନି ନା ଆଚ୍ଛା ତାହେଲେ ଗୋଟେ କାମ କର ଏଇଟା ସବୁ 2009 ର ତ 9 ଗୁଡାକର ଆପଣ ନେଇଯାଆନ୍ତୁ ଇନଷ୍ଟ୍ରକ୍ସନ ସେଇ ଟାଇପ ର ଚାର୍ଟର୍ସ ଅଫ ଦି ଆକ୍ୟୁଜ୍ଡ ହେଲା ଯୋଉଗୁଡାକର ପ୍ରି ମ୍ୟାଚ୍ୟୁର ରିଲିଜ ହେଇଥିବ तार इंस्ट्रक्शन बंची कि ना बेल जाइए सब फॉर्मेट करके देदेवे हाँ whether he has been released prematurely by the government, number one, and if not whether he is alive or not, number three, period of detention if he is there in custody, ये टाइप रो गोटे फॉर्मेट करके मगेज अपन मैंने बसी जातु जहाँ जहाँ दरकार 1 2 3 4 करके गोटे फॉर्मेट देखी कौन कर
up to item 52.
Whether the appellant has been, as per the state government, if he is furnished, whether the appellant is alive or dead, if dead, so and so. Either add करो अपनो if he has not been released on bail, the period of detention, custody certificate to be produced. Simultaneously, criminal antecedent, health condition, criminal antecedent, custody, गुड़ाक सब मगे है
एग्जॉस्टिव
एग्जॉस्टिव गोटे गोटे पठेदेवे सुपरिटेंडेंट को जोटा ये पठेया सेटा पठेदेवे आउ गोटे पठेदेवे आईएएस है तो रिपोर्ट पड़े आसो एकाठी है दिस इज आइटम नंबर 20 रु लास्ट पर्यंत सर लिखिदेवे the land council for the state seeks some time to obtain instructions. These are the this is the jail criminal appeal of the year 2009. The land council for the state submits that he may be given some time, he or she may be given some time to obtain instruction as to whether the petitioner has been released on released prematurely as per the order of the state government. Number one, whether he has been released on bail, if not, to produce the custody certificate, and number 3, the health condition from the jail superintendent, and from the concerned IAC about the criminal antecedents. Common जो इसकी लिस्ट अच्छी जार जो मैटर असाइन कराई कोथरे मिस्टर प्रधान को ये कराई कोथरे मैडम को कराई जार जो मैटर का ना लिखिदेवे लिस्ट दे देवे है ना हाँ हाँ ये छुट्टी पर रख then what is this item hearing Mr. Nayak No, this is up to 52. This order would be passed. Item number 20 to 52. Baki rara 53. 53 where is Mr. Nayak?
Let me click on.
डिस्प्ले लगा दी 53
Maybe pardon you, Lordship, I'm moving for another bail in this matter, Your Lordship. Lordship, you give us some time, Your Lordship.
No, there is a 53 number case कहाँ दायित्व
It's a night paper book.
नहीं अपने पाई ना दी पेपर बुक तो ही नहीं जीवे अपन
Yes.
है
Yes.
लेपन the land and council for the item number 53 the land and council for the appellants also the land council for the state submits that they have not received the paper book. Let
They
the
have not received the paper book.
not for accused, they have not received the paper book. Let the copy of the let a copy of the paper book be supplied to the land and council for the appellant. So also the land council for the respondent by the registry. Matter be placed after summer vacation could be.
Lordship.
Job.